Emergency had to leave to Patna yesterday, so 2 weeks, my lord.
At the request of the learned counsel for the parties, list this matter again on দু সপ্তাহৰ পিছত দিয়ক 17th of September
17th or 24th?
24th কৰি দিয়ক 24th of September. Yes.
May I please? I beg to mention, my lord, item number 53.
53.
Lordship.
Huh.
Day before yesterday, Lordship was pleased to ask for some instruction, my lord. Just I was informed that instruction not received.
Let the matter reach.
Lordship.
Sometimes it comes during the day.
Lordship.
No instructions.
No instruction. That is why, my lord.
Learned APP submits that the instruction sought for is yet to be received. List the matter again on 28th of August. 28th of August.
Yes, interim to continue, my lord.
The interim order passed earlier continues.
I'm obliged.
Lordship, beg to mention item 15, Lordship.
1-5.
1-5, Lordship.
Huh.
15.
My lord,
Yes.
for the petitioner, my lords, we object, we do not give the consent.
Huh?
And for the petitioners in this case, item number 15, we do not give the consent.
You do not have the consent.
We do
Why
give
not?
the consent. My lords, the case diary has been received well over 6 months ago.
Huh.
Time and again, the orders will reflect that they have been, the PP has been taking time to go through the case record.
Huh.
There is an interim in this matter,
Huh.
but we want to finish the matter, my lords. They have been taking time since last 6-7 months. Day after day, this is being.
Yes, PP, what do you say? And that is all right. Would you like to have it today or do you want to have it on? He is expressing urgency. Madam?
And for the response number 2, I'm led by Mr. P. Nayak, Lordship.
Huh.
Lordship, he has, Lordship, parted matters in 3 different courts
No,
today.
today we will adjourn it, no difficulty, but give us a date on which, because he has expressed urgency, just
First week of September, my lord.
No, my lords.
2nd of September,
2nd of September, my lords.
3rd?
Yeah, I'm not supposed to even.
Uh-huh.
Okay, my lord.
No, we'll record your objections, no
Yes,
difficulty.
yes,
2nd or 3rd?
2nd of.
2nd. Ms. Burwa, learned counsel, appearing for the respondent number 2, has expressed difficulty on the part of Mr. P. Nayak to appear in the matter today. Learned
My
PP
lord.
has
2nd September, there's a bit of difficulty for 2nd September. Just
3rd?
From 3rd.
Why from the corner? Why play from the corner? Huh?
No, my lord. Senior counsel, Mr. Fukun, he has some difficulty.
So when? 3rd?
Third.
Maybe 7th?
Third.
3rd? Yes, 3rd. Good. The learned PP has received the case diary. He prays that he may be given the opportunity to have the updated CD in the matter stuff. You are Mr.
P. Chaudhary.
P. Chaudhary. Mr. P. Chaudhary, learned counsel for the petitioner has objected to the prayer for adjournment. Stop, however, in the interest of justice, place this matter again on the 7th of September.
Third.
At the 3rd of September 2026. Interim order passed earlier continues.
Deeply.
Yes, madam.
Lordship, I beg to mention item 39.
39.
The PCB has not arrived, Lordship.
Item 13 likhibo. Ms. S.C. Ahmed appears for the petitioner. Learned APP has submitted that the CD is awaited. List again on.
Interim is there on 10th.
10th of September 2026. Interim order passed earlier continues.
Lordship, with regard to item number 48, Lordship, we had filed an additional affidavit.
48.
Lordship, we had filed an additional affidavit.
Call for it.
Lordship, it is not on record, Lordship, plus I spoke to the respondent, so Lordship, may I pray in the first week of September, Lordship?
Okay. Item number 48.
48, Lordship.
You are appearing for
The petitioner, Lordship.
petitioner.
Okay.
The learned counsel for the petitioner has submitted that an additional affidavit has been filed
Yesterday, Lord.
yesterday, which is not on record, full stop. He accordingly placed the matter to be taken up on the after a week. List this matter again on the 8th of September.
Eight lordship, some difficulty, seventh lord.
7th of September,
After 7 lordships, my senior will be out.
9th of September,
9th of September, lordship.
May it please your lordship. Lordship, I beg to mention item number 23, my lord.
23 years.
This matter may be taken up after a week.
At the request of the learned counsel for the petitioner, list this matter again after a bail matter will fix karo. If 15th, bail her.
Next week, my lord, any date. my lord.
No, next week. We'll have it on the 8th or 10th. 8th of September.
Oblige.
Yeah, please, Your Lordship. I beg to mention item number 21. from the
21.
daily, my lord. I'm for the petition, I have taken consent from the other side.
Ah,
Lordship, my lord, after 10 days, my lord,
at the request of the learned counsel for the petitioner, list this matter on the 8th,
Lordship.
8th of September,
Lordship,
10th of September.
10th of September. One more pair, my lord, in respect of item number 28. I have employed, my lord, CD not received. 28.
Are you on interim? No.
Yes, I'm on interim, my lord. So long that maybe.
10th of September, item 28, huh?
Lord,
CD is awaited.
highly blessed.
May I please your,
Interim order continues.
may I please your lordship, I beg to mention item number 35.
Hmm.
CD is not received, so interim may continue lordship.
Learned APP has submitted that the CD is yet to be received. List again on 11th of September 2026. Interim order passed earlier continues. Are you on interim?
Yes, Your Honor.
Interim order
Obliged.
passed.
With the consent of others, lordship,
Hmm.
item number 49,
49. Ah,
hearing matter, lordship, can it after a week, lordship, and we have consented on 15th, can it be, lordship?
15th of September.
Lordship.
At the request of the learned counsel appearing for the parties, list the matter again on the 15th of September 2026 under the heading here, under the hearing column. Yes,
Lord, item 37, my lord. This is no CD was proposed, perhaps that has not been received, my lord.
37.
37, my lord.
CD call for বিলাকত তেনেকে লিখি দিব।
Interim order, my lord.
Learned counsel for the petitioner লিখি দিব। APP submit CD is awaited. List on
11.
11th of September.
Interim may be called.
Interim order continues.
Obliged.
May I please your lordship? Lordship, I beg to mention item 18 and 19. Lordship, my senior counsel is out of station, so lordship, kindly matter may be adjourned for a week.
CD awaited, sir. CD awaited. Or scanty session. At the request of the learned counsel for the petitioner, list this matter again on. Choose a date.
Next week, lordship.
September 2nd week.
Okay.
9th or Duke. 11th of September. Yes.
Maybe this lordship, I beg to mention, I don't know, 38 lordship, CD not received. Interim is there.
Okay, petitioner appears. List again on 14th of September.
Interim may be.
Interim order continues. Yes,
Lordship, I beg to mention AB number 1784. It was last listed on 18th August. But for CD was not received. But later on I came to from PP, CD has come.
when was the date fixed?
27 August. Lordship, it may be 24th August.
You'll have to move a mention when a fixed matter আহিব. We can have it on 24th.
24th.
24th, you give a mention memo. You have to give a mention memo, madam.
Yes.
24th or allow it. Yes.
My lord, I beg to mention item number 56, lordship, supplementary list.
Hmm.
Lordship, here in this matter, one IA has been filed, we have filed an affidavit in opposition also, lordship.
Ah,
Lordship, trial court report is also there, lordship, matter may be fixed for admission, lordship.
what is the IA about?
I have to vacate the interim order, lordship.
So,
Yeah, maybe service, well, state of Assam, another service.
you have moved the IA.
Yes, lordship. They have filed that.
State has moved the IA, so definitely you must have given them copies.
Copy I have received, lordship.
Should we fix it for admission or you want to contest the IA today? Heard learned counsel appearing for the petitioner, also heard the learned additional PP. At the request, list this matter again on the 14th of September for admission.
Interim order is there.
The interim order continues.
Highly obliged, Lordship.
May it please the Lordship. Lordship, I beg to mention item number 22 and 41, both are connected. FR and CD is not available.
Item,
Item number 22 and 41.
22
Yes, Lordship.
and
41,
41.
both are connected. FR and CD is not received.
It would likhibo 22 likhibo list along with item 41, AB number 2198 of 2026. Full stop. The learned APP submits that the case diary is awaited. Full stop. List again on
22, my lord, charge sheet submitted. Dobogana?
22 charge sheet submitted.
41, same.
Yes, have your instructions. Charge sheet is submitted, so we can close these bail applications. You can go and move the trial court. We'll take it up when the matter reaches. Be here. Yes, madam.
Please, your lordship, I beg to mention item number 43.
43.
I want to adjourn it for the day as my senior is not out of station, as my senior is out of station.
Your senior is not out of station.
Senior is out of station.
Out of station.
CD is awaited, lordship.
CD is away.
43.
Huh?
It is not available.
Heard Ms. So-and-so learned counsel appearing for the petitioner. Learned APP submits that the CD is awaited. List again on 11th of September. Are you on interim?
That's not in interim.
Or then we'll have it sometime quick. 27th August.
Well,
27th of August 2026. Yes.
Your Lordship, I beg to mention item number 46, the conducting counsel, Mr. K.P. Pathak, who is appointed as the amicus, has some personal difficulty.
2009 matter. God help you. Although the matter relates to the year 2009, it is submitted on behalf of Mr. K.P. Pathak, learned amicus, that he is not in a position to attend the proceedings today, and accordingly a date has been sought for. An adjournment has been sought for. Full stop. Learned APP is present. Have you informed the other amicus?
Yes,
For respondent number 2? Have you informed the other side? The amicus appearing for the respondent number 2 has been informed. Full stop. List this matter again on 14th. 14th of September. Yes.
May it please the Lordship. Lordship, I seek your permission to go through the records of item number 17 and supplementary item 51, madam.
17 and
And supplementary
51. Declare.
May I please the Lordships? The learned counsellor submitted the objection and my learned senior from the Manipur High Court has instructed me to fix a date for hearing in motion.
Choose one. Choose a date.
17 of
September, 17th September. At the request of the learned counsel appearing for the parties, list this matter again on the 17th of September 2026. The respondents have filed their written objections.
There is no order for CD.
Yes.
So at the time of hearing, CD may be required.
They has filed their objections. Full stop. Call for the case diary. List as aforesaid.
LCR is not. It is a charge sheet.
Charge-sheeted case.
LCR is required.
Call for the scan copy of the TCR.
17th here.
Instead of CD, make it list again on the 17th of September. Yes, sir.
It's also a bail application filed on behalf of the petitioner, my lord,
Hmm.
paying for a regular bail, my lord,
Hmm.
in connection with NDPS case number 40 of 2026, my lord.
Ah.
The petitioner is behind the bar since 28/1/2026, my lord. The evidence has already been completed, my lord. Recording of the evidence has been completed. Search sheet also has been submitted. And after the charges are also framed, case is going on, my lord.
Hmm.
And then a regular bail application was filed before the line of trial court, my lord. The trial court has already rejected, my lord, for which the present the bail application has been filed before your lordship, my lord.
Hmm.
Commercial quantity, can be shared.
We will call for the scan copy of the
It has
TCR
to be
for
necessary, my lord.
heard Mr. N.C. Das, learned senior advocate, assisted by
J.
Ms.
Boishya.
J. Boishya, learned counsel for the petitioner. Mr. Parashar, learned APP is present. Call for the scan copy, then you give this one. Praying for bail under section 483 in connection with special NDPS case number so-and-so. Call for the scan copy of the TCR list again on 2nd of September.
Obliged, your lord.
Wait, please, Your Lord. I think that TCR will be required, my lord. It's from Gauhati itself. It's page 2, my lord.
Heard Mr. N.J. Dr. learned counsel appearing for the petitioner. Mr. Parashar, learned APP is present. Application under 483 BNSS in connection with dispute PS case number 752 registered under 21C of the NDPS Act, which has culminated in NDPS case number 13 of 2026 pending before the learned court of special judge NDPS, Kamrup, Metro. Call for the scanned copy of the TCR list again on
Can it be on 2nd, my lord?
2nd of September.
Fine.
Yes.
I'm obliged, master. Please, please.
May I please, your lordship?
Hmm.
FIR is at page 9, lordship. Allegation against me is under section 304 of subsection 2, lordship, where the maximum punishment is up to 3 years, lordship.
Hmm.
I'm since last 12 days I'm behind our lordship. And lordship, notice under section 35(3), lordship, has not been served to me, lordship. So which is necessary.
It has been charge sheeted.
No, lordship, not that.
Snatching of girlfriend.
What do they call it in Assamese? Silonisul. Heard Mr.
Yes, Ali, lordship.
S. Ali, learned counsel paying for the petitioner. Mr. Parashar, learned APP is present. Application under 483 in connection with Bholumuk PS case number 112 of 2026 under section 3042 of the BNS 2023. When were you arrested, sir?
Lordship, on 8 August, lordship.
Petitioner had been arrested on 8th August 2026. Full stop. Call for the case diary list again on
27.
huh?
27.
27th of August 2026.
I'm obliged.
Lordship, this may be taken up with 29 later, at a later time.
29 lot lage mati boliche. 29 file is here otherwise.
With 29 during bail hearing.
29 or serial matibo.
I'm obliged.
Where is Osipar?
Yes, sir.
There is a group fight matter between the two groups matter. It is number 1 to 4 and informant party matter. It is the 5 to 8 matter. They accidentally they have come in the same matter and they were also assaulted. And one person your lordship, finally this is the last page.
Last page.
Check on the last page, my lord. Respondent number 5. Sorry, petition number 5. And it is supported by page 29, kindly see, my lord. There are page 29, paragraph 4, my lord. Reasons for arrest, serial number, my lord, 4. Other party, one person arrested, my lord. In that connection, this was observed, my lord. Serial number 4, just have a look about this injured person, my lord. He is specifically alleged to have assaulted your lordship got it, man. page 29, bottom
Yes,
4.
assaulted Qazi Sadiq Akhtar.
Who sustained grievous head injuries requiring 14 stitches as supported by the medical officer.
So you are Qazi Sadiq Akhtar.
He is also, no, I am one of them.
Petitioner number 5.
I'm just showing my lord, your lordship, kindly see.
Seven others.
Now FIR kindly see, my lord. Now to be clear, my lord. Page 14.
So you are petitioner number 1 is on a
That
this
one.
Sadiq Akhtar is
number
petitioner
five.
number 5.
5.
Okay.
Till today, he will come to medical college, my lord. To check up.
And
And as of FIR, my lord, page 14, kindly see, my lord. On the face of the FIR, this group fight is between 1 to 4 and the informant party, as per FIR. There was kind of paragraph, page 15, top file. Case going on among themselves, my lord. Statement of everything. Now, course case also page 25. Course case we have filed. In that case, one person arrested, and I have shown to your lordship that part, my lord.
then one,
Over 1 to 4, I think, my lord, your lordship may require. Other part, in my humble submission, my lord, your lordship may consider interim, my lord. Very fairly I am submitting, my lord.
yes, sir, what do you say?
Yes, scuffle within two party, but here as per the affair, father got injury in head, brother injury
there.
head and
No,
left hand broken.
The-
Father was shifted from Sri Bhumi Civil Hospital to Silchar Medical College
Yes,
Hospital.
yes. That is not, I am not denying, my lord. Both parties sustained injuries, my lord.
Both party,
Just a minute.
here this city has to be
Course case, page 25.
maybe cross.
We filed earlier in point of time, my lord.
With sharp weapon.
No, that I am not disputing, my lord.
Yes.
That is. But question, my lord, this person I have stated in paragraph 4 clearly, my lord. They are coming in a vehicle, my lord. And while they reaching home, in the midst of the way, my lord, this thing was happening, so they intervened rather, and ultimately they have been assaulted. 2 persons assaulted, one is badly assaulted. Page 6, paragraph 4, I have stated details, man. About this 4
For
persons.
5, we can consider. The rest, I think we'll have to go
Others,
to the
there is
city.
no direct, my lord.
Huh?
5, 6, 7, same, my lord, 5, 6, 7, 8, my lord. They are not at all, they are not neither related to them also, my lord.
No, this arrest memo is of on the
In-
basis of your FIR.
In my FIR, he was arrested.
Okay.
In that way, it is mentioned, my lord. I think, my lord, the city will reveal your lordship kindly consider, my lord.
Mr. Parashar,
5. because
Sadiq
the-
Akhtar is 5 was injured himself. Then number 6 has lodged the other FIR in which the other persons have been arrested.
He is the
So when he went to lodge the FIR, there was not immediate necessity of arresting him. 5 and 6, I think we can consider.
Well,
They'll appear before this thing. The others will consider as and when the
only short
it is
basis.
try to keep it short. From Karimganj, heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by
IU Chaudhary.
Ayu Chaudhary, learned counsel for the petitioner, Mr. K.K. Parashar, learned APP is present. This is a bail application under section 482 of the BNSS in connection with Pathakandi PS case number at page 2, so and so. The learned senior counsel has submitted that on the basis of an FIR lodged by the petitioner number 6, the informant in the case where the present petitioner seek the privilege of a pre-arrest bail had been arrested, and the petition number 5 had been injured in an assault by the informant and other and other colleagues. Full stop. He has accordingly prayed for an interim protection to be granted to the petitioners since there is enough material to show that the petitioners were attacked rather than the petitioners being the assailants, full stop. The learned APP has prayed for listing the case on, when do you want it? For the CD?
Sri Bhumi, my lord. On 28th.
28th of August 2026 to obtain the CD, full stop. List again on 28th 8 2026. Call for the CD. In the meanwhile, the petitioner number 5 and 6 shall appear before the investigating officer in connection with
Pathakandi case number
Pathakandi
105.
PS case number 105 of 2026 to participate and cooperate in the investigation. In the event of their arrest before the next date of listing, they shall be released on bail on furnishing a bond of rupees 5,000 each with one local surety to the satisfaction of the arresting authority. A petition number 5 and 6 position নাম কিটা দি দিব?
And 6.
May I please, Your Lordship? Pre-arrest bail application, my lord.
Hmm.
Petitioner is a lady, my lord. FIR at page number 9. FIR at page number 9, my lord. There are 3 accused person, my lord. I am for the accused number 2. 1 and 3 are already arrested, my lord. One is the husband of the present petitioner, my lord.
Huh?
One, accused number 1 in the FIR
Huh.
is the husband of the present petitioner, my lord.
Okay.
Because, my lord, 1 and 3 has committed something, therefore, this petitioner also implicated in this case.
Hmm.
The allegation is that, my lord, the accused person took Aadhaar card, PAN card and voter ID from the informant by.
Yes, she's a lady. Will allow her to appear. You have got
Lordship,
2
but
persons in your grip.
Directly allegation, not against who?
Lordship.
Heard Mr.
H. Ahmed.
H. Ahmed, learned counsel appearing for the petitioner. Also heard Mr. K. Parashar, learned APP. Call for the, this is an application under 483 in connection with so-and-so. Haju PS case number. Call for the case diary list again on 9th of September 2026. The petitioner shall in the meantime appear before the investigating officer of the case to participate and cooperate in the investigation process, full stop. In the event of her arrest before the next date of listing, the petitioner shall be released on bail on furnishing a bond of rupees 5,000 with one surety of the like amount to the satisfaction of the arresting authority. A petitioner shall appear য'ত কৈছো তাতে ডেটটা দি দিব 28 August কৰি দিব on or before 28 August. Yes, sir.
Yes, Lordship, FIR page 8, Lordship, pre-arrest bail application, Lordship. The allegation is that, Lordship, petitioner set fire on the hotel of the informant, Lordship. So at this stage, Lordship, my humble submission, CD may be called for, Lordship.
Arson,
Lordship,
why burn down a hotel?
this is an allegation, Lordship.
Heard Mr. Azad Ahmed.
Yes, sir.
Is it? Learned counsel for the petitioner also heard Mr. K. Parashar, learned APP. Application under 482 in connection with Mankacha PS case number 118 of 2026. We'll stop. Call for the case diary list again on
Thought that,
Mankasa, third.
3rd of September 2026.
Lordship, may I please have a question? This is an anticipatory bail application whereby the petitioner is apprehending arrest in connection with a complaint case lodged or proposed to be lodged by Smriti Padikar Roy Sarkar.
Proposed to be lost.
Yes, so here what has happened, Lordship, is the petitioner and one individual, namely Smriti Padikar Roy Sarkar, they have a cordial relation
We'll
with
take
each
it.
other. So out of the said,
Instruction, madam.
Lordship,
We'll take instruction.
Instruction.
I would like to submit.
No, we give an anticipated bail on with regard to which case?
Lordship, the thing is that.
Where is the PS case?
It's in Gusaigaon Police Station.
Where is that? We don't have the number, we don't have anything.
Tamar Haq PS. Your name.
Do you understand, madam? A bail or an anticipatory bail has to be against a particular
Yes, sir.
investigation process, is it not?
Your
Where is it?
Lordship,
You said proposed.
Lordship, police personnel from Gusaigaon Police
Then
Station.
on a marriage proposal, lawyer should be preparing the divorce papers or the huh? Or the maintenance papers. Cannot be.
Lordship, it's not a blanket cover. We are seeking anticipatory bail on a.
Suppose you are saying that
Yes, sir.
you took some money, she took some money, there is some allegation here and there. Now, this lady also lodges an FIR saying that you robbed her.
Sure.
You beat her up. Your husband also participated in it. You'll have a blanket cover because it's an FIR by the lady herself. The same name. So we cannot we cannot say that don't arrest her if any case is lost by this lady. Can we say that? No. So we'll have it on Monday. Let him have the instructions. If there is an FIR, we'll consider your case. List again on the 24th of August, allowing the learned APP to have his instructions whether any case has been registered against the present petitioner in which?
Tamar Haq PS.
In?
Tamar Haq PS.
So and so PS, huh?
Oh, bless you.
Yeah, please, your lordship. My lord, in this case, I am husband, my lord.
Hmm.
This is a family dispute, my lord. And other sections are bailable, my lord, except 85, my lord, the NSC non-bailable, my lord. And for restitution of conjugal rights, my lord, I have served a legal notice before the FIR, my lord. After receiving FIR, my lord, she filed the instant FIR. My lord.
After receiving notice of
Notice, my
restitution of conjugal rights.
my lord, notice.
But this is, but by the FIR, it looks like more you are interested in going to a gym. You want to tie up someone and beat them up.
No, my lord, this is the allegation, my lord. I have filed a, my lord, page.
Where is it?
Page number 21, my lord. Lord, this is the legal notice, my lord. Relevant portion, my lord, 23, my lord.
This is when, dated when?
10/6/2026, my lord.
When was it sent?
It was delivered, my lord, instantly, my lord.
10/6/2026.
2026, my lord.
10/6.
10/6, my lord.
Okay, and
FIR filed, my lord, 1/7/2026, my lord. Page number 14, my lord.
your bill was rejected by the trial court.
Trial court, my lord. And there is a possibility to settle, my lord.
It was the earlier 498, now 55 BLS.
That is okay. Let him appear. Even the Supreme Court says that without an investigation, even under these allegations, automatic arrest should not be the process. Heard, Mr.
FL Oscom.
FL Oscar Learned Counsel appearing for the petitioner also heard the learned Mr. Parashar, the learned APP, full stop. This is an application under 482 of the BNS paying for PRS bail in connection with page number 1, this is Silchar, PS case number so-and-so, full stop. The learned counsel for the petitioner has submitted that the petitioner is willing to appear before the investigating authority and participate and cooperate in the proceedings, full stop. He has submitted that the mother and the sister of the petitioner have already been granted pre-arrest bail, the privilege of a pre-arrest bail by the learned court. Stop. Call for the case diary. Petitioner shall appear before the investigating officer on or before the 28th of August 2026 to participate and cooperate in the proceedings, investigation proceedings, full stop. In the event of his arrest before the next date fixed, the petitioner shall be released on bail on furnishing a bond of rupees 5,000 with two sureties of the like amount to the satisfaction of the investigating authority. Stop list again on the 11th of
11th.
September 2026, along with the case, allowing the learned PP to obtain the case diary. The petitioner shall not in any manner threaten or coerce the informant or her family members during the period.
Obliged.
May I please, Lordship, 482 application, FIR is at page 22. May I?
Yes,
FIR is at page 22. I beg to state that on 24/6/26 at about 12 noon, my father so-and-so left home to work in agricultural land near our family pond. The distance between our home and our family pond is approximately 150 meters. Thereafter, at 2, my paternal cousin, namely Abu Bakr, went to the pond for bathing, and my father so-and-so lying dead in an injured and bloodstained condition near the pond guard. Thereafter, my paternal cousin so-and-so screamed loudly, and upon raising an alarm, local villagers scattered at the spot and informed the ward member, and he subsequently informed the PS. Thereafter, the in charge of PS, along with his team and circle officer, visited the place of occurrence. Thereafter, they conducted an inquiry.
all for the CD, sir.
Lordship, Lordship, actually, I am a government school teacher, which is page 27, my ID.
103, my lord.
And on 20, page 28 is a certificate by the headmaster of the school, whereby he certifies that on that particular day from 9 to 3:15, I was at school. Page 29 is also the daily attendance register.
For the present, we'll allow him to appear. In case there is any material in the CD, because he's a government servant, the moment he is arrested and later on you do not find anything to do, his suspension and termination of service follows automatically, almost, is it not?
My lord, mentioned that, my lord, but my objection 103, my lord.
No, we understand, but here the only allegation is that he had a land dispute with this man,
My lord,
is it not?
Only on suspicion, my name is in the
Huh?
Only on suspicion. Nobody
It
has
starts
seen,
with a suspicion, sir.
nobody has seen me or.
And
that
since he has
could
already been
also-
certified to be in the school that day,
Yes, Lordship.
only on the, but
Yeah.
if the CD reveals anything, we are going to withdraw all protection.
time of the incident,
12 noon. 12 noon, the body was found. If we find that the murder occurred 8 hours before, that means in the morning. So the school presence will not help him in any way.
Lordship,
The
in the
interest
FIR it is already mentioned between 12 and 2.
No. He was found dead at 12 noon.
At 2. He went to the.
Oh, he went for a bath at 12.
Yes.
This man was in school. Apparently, the certificate says. Okay. Heard Mr. Yukhan. The counsel appearing for the petitioner also heard the learned APP, Mr. KK Parashar. Full stop. This is an application under section 482 of the BNSS 2023 for grant of pre-arrest bail in connection with Pathakandi PS case number 84 of 2026, registered under section 103 within bracket 1 oblique 238 oblique 351 within bracket 3 oblique 3 within bracket 5 BNS 2023. The learned counsel for the petitioner has submitted that as per the FIR, the father of the informant had gone to take bath in the local pond at around 12 noon, and later his dead body was found at around 12 p.m. At 2 p.m. by the paternal cousin of the informant. Full stop. The learned counsel for the petitioner has submitted that the petitioner herein, although a named suspect in the FIR, serves in serves as a teacher in
Sunatula MEM School,
Sunatula ME School,
Pathakandi.
village Sunatula in Sribhumi, full stop. The learned counsel for the petitioner has drawn attention of this court to the certificate issued by the headmaster of the aforesaid school that the petitioner had been present in the school from 9 AM to 3:15 PM on 24th of June 2026. That is the date of the incident, full stop. He accordingly prays that the petitioner may be granted the privilege of a pre-arrest bail so that he may participate and cooperate in the investigation process, full stop. APP has submitted that the allegations leveled are very grievous. Therefore, the petitioner may not be allowed the privilege of a interim protection at this stage, full stop. This court notices that the petitioner has been named as a suspect in the FIR since he had a land dispute with the father of the informant, and further, the certificate of the headmaster of the school also gives an alibi, gives a prima facie alibi to the petitioner that he was present in the school at the time of the incident, full stop. Considering the above, this court is of the opinion that the petitioner should be allowed to appear before the investigating officer to participate and cooperate in the investigation process. Full stop. Accordingly, the petitioner shall appear before the investigating officer on or before the 28th of August 2026 in the list again on the 15th of September 2026 along with the updated CD. Full stop. It is provided that in the event the petitioner is arrested prior to the next date of listing, he shall be released on bail on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the arresting authority, in the event the petitioner appears before the investigating authority on or before the 28th of August 2026.
Keep your best.
মাজত কোটা দি থৈ মাৰিব লাগিব। ইখন মাজত কেলে?
Wait, please, your lordship.
Since we are taking up a criminal bench, I think we can take this up after some time. Otherwise, all the other matters would be waiting.
Sir, bail hearing matters.
After the bail hearing matter.
Here in this case, lordship, FIR your lordship will find at page 10, relevant portion of page 13.
Page
13.
13.
Lordship.
Ah.
So lordship may skip that page 13. Lordship may kindly see page 14, first paragraph, lordship. Because I am on that search procedure, because contraband was allegedly recovered from my cloth, lordship. Page 14, paragraph, first paragraph, lordship. May I read?
Yes.
So here I'm just pointing out to your lordship the last line. Thereafter, I served a notice under section 50 NDPS Act to the detained individual, namely Alamuddin Borbia. Here nothing is written whether he was informed about the right or not, because the Honorable Apex Court has clarified that informing the right and serving the notice or giving the choice is two different things. So here they have only served the notice without informing the right to right under section 50 of NDPS Act. They have to inform that you have a right to be served before gazetted officer. So that they have not stated. Now I'm taking your lordship to the notice. Page 31, lordship may kindly see. Here he first said, lordship, whereas there is reason to believe that narcotic drug, psychotropic substance, controlled substance, and or documents, articles, and things which may furnish evidence of commission of an offense under the NDPS Act are in your possession. Therefore, your personal search is to be conducted by the undersigned. So first that, then if you so require, such search will be conducted in presence of the nearest gazetted officer or magistrate. So he has not said this is my right to be searched before gazetted officers. In similar situation, lordship, our High Court has also dealt with a similar notice that this is not this does not amount to informing the right, lordship. So I am just placing that judgment before your lordship. And in last paragraph also, your lordship will not find that he has given any choice. It is simply pre-typed, lordship. I do not require that my personal search may be conducted in presence of nearest gazetted officer. So it was pre-typed. So there was no option that I do require. That option is not there in the notice itself.
No. Was not apprised of the legal right provided under section 50 to refuse to allow the police party to take their search. Not for being searched. No, here the option is given.
No, lordship, here, lordship, just I am placing the Suraj judgment of honorable apex, so that will make clarify, lordship.
No,
Because here the-
what was the exact words of the notice in the?
Notice is not here, so but that is there in
Then-
Supreme Court judgment.
Give us the
It is
language
there in
of
the
the
Supreme
notice.
Court judgment.
Where is that notice?
Paragraph 15, lordship,
50?
15.
1. Here the notice is different.
No, here, if I am not wrong, lordship may kindly see paragraph 15, that notice. In the presence of aforementioned funches, why I, the PS in charge,
Whether
as the driver.
regarding their personal search, asking them whether they would offer their personal search to me
To me,
or to gazetted officer.
yes, regarding their personal,
Ah.
asking them, so that option was given. Here also the similar situation that I will search, full stop. Then if so required, such search will be conducted in presence of the nearest gazetted officer or magistrate. But they have to say that this is my right under section 50 of NDPS Act. They have not said that part, and that part is, your lordship will see, paragraph 16 clarified that aspect of the Suraj judgment. Paragraph 16, may I read it? The above Panchnama indicates that the appellants were merely asked to give
That
their.
is already there in the earlier order, it's at para 7.
Lordship.
Where are we reading it? Yes, sir, what do you say?
So far the language is concerned, my lordship may kindly see the annex, under section 50 notice, my lord. What is reply, my lord? I have been informed and understood a notice of personal search under section 50 of NDPS Act.
Hmm.
I do not require that my personal search may be conducted in presence of nearest gazetted officer. So every fact has to be, my lord, dealt with, my lord, different, my lord. Here, my lord, so far the language is concerned, my lord, in my humble submission, my lord, cannot.
The requirement is to inform him of the right
Yes,
to refuse a search.
yes,
Here, the notice says that I will search you.
yes, sir.
If you want, I will call a gazetted officer
Yes.
or a magistrate. He says, I don't need a magistrate or a gazetted officer because I'm not allowed to refuse.
That is not the part.
Oh, when you don't give him the information that you have the right to refuse, you may ask for a gazetted officer or a magistrate. That is another thing.
Right.
Search you, I will under any circumstances. Whether you have a gazetted officer or not, I am going to search you. If you want, I'll call a gazetted officer. That is what the notice says, if I'm reading correctly, is it not?
Yes, ma'am. Yes, the problem,
Therefore, your personal search will be conducted by the undersigned. It will be done.
Yes, if you so require.
Now section
search will
50
be-
says, section 50 says that you have to inform about the right to refuse.
Hmm.
That I refuse to allow you to search me. I don't want you to search me. That is what I think this Suresh case says.
Yes.
What section 50 says, my lord? There is no such.
The legal right provided under section 50
Lord, sir, kindly.
to refuse or to allow the police to take their search.
But here, my lord, what the section 50 says, my lord.
Okay, can we interpret it more than the Supreme Court? Sorry.
My lord, sir, kindly see, my lord. Whether when any person duly authorized under section 42.
Read paragraph 16 of the judgment.
Yes.
Supreme Court has interpreted it how it is to be.
That,
If you want me to differ, first a larger band, then a more larger band, then ultimately this, can I do that?
The word which Lordship has now just used, that is also reflected in Bishambar versus State of UP, Lordship. That's similar wording.
The only thing is that his right to refuse
Yes.
to be searched.
If refuse for.
I will totally refuse a search. No, I am refusing a search.
I also cannot defer, my lord.
Huh?
I also cannot defer if it is said that, my lord, you have the right to refuse.
Refuse a search.
Refuse.
Now I am refusing to get myself searched.
Defer, my lord.
And if I'm to be searched, then I would like to have it before a gazetted officer. That is the right he has.
Yes. That's-
It was not informed.
Yes.
Therefore, a bail was
Yes,
granted in
these are
another
different,
occasion.
But, subject to correction, my lord, what I understood, my lord, correct, if I have understood, my lord. What the act says, my lord.
That argument would have worked
Just
prior to
If a law.
Suresh.
Lordship. If
That argument
he shall, if such person so requires. Only that much, my lord. If he shall.
under section 50 of the NDPS to refuse to allow the police party to take their search. They can refuse totally
That is the.
and opt to have being searched before a gazetted one.
Lordship.
So here here the option given is I'm going to search you. And if you want, I can call for a gazette.
That is also. That is.
So if you don't want a gazetted officer, even then I will search you.
No.
Yes.
No.
Where is the option to refuse? That is how the Supreme Court has. I would like to interpret it in the way you have projected. Refuse to be searched without a gazetted officer or a magistrate. That is his right. Yes, even that right was not given.
Lordship.
The option was I will search you.
Yes.
Even if you go by your
If
interpretation,
you so require, if you
Then
so
I will.
require, your search will be conducted. If we let, my lord, what the act says, if so require, if you so require. That is why it is said, if you so require, search will be conducted. My lord.
but then they have to be updated about Suresh. A little change in the format,
Lord.
because this is also a typed format. Page 31 is a typed format. You simply need to insert, what to say, control alt delete, and then type it out again. Huh? Yes,
Lordship. Otherwise, madam, if that part.
Optionless.
I cannot,
heard. The learned counsel is paying for the petitioner. You are Mr. A. Ahmed.
Yeah.
Azad Ahmed, huh? Heard Mr. A. Ahmed, learned counsel is paying for the petitioner. Also heard Mr. MP Goswami, learned APP. Full stop. This is a petition under section 483 of the BNSS, praying for grant of bail to the petitioner who was arrested on 23/9/2025. Huh?
1/6/2025.
Then where does 23/9/2025 come in from?
I'm sorry, Lordship, this is wrongly written. It was mentioned earlier.
Huh?
It was mentioned.
So your control all and delete did not work. Who was arrested on 1/6/2025 in connection with special NDPS case number 61 of 2025 pending in the court of the additional session judge, FTC, Sri Bhumi, arising out of Badarpur PS case number 97 of 2025, registered under 21A/22C of the NDPS 1985. Full stop. The learned counsel for the petitioner has drawn attention of this court to the notice under section 50 of the NDPS Act, which was served upon the petitioner at the time of his search, to contend that the same did not fulfill the mandate of informing the petitioner of his right to refuse search by the police party, and therefore the search of the petitioner being not in accordance with law, the arrest of the petitioner in the present case requires an interference by allowing him the privilege of bail during the period of trial. The learned counsel has placed reliance on the case of Suresh and others versus the state of Madhya Pradesh, reported in 2013, 1 SCC 550, wherein it was held that when the appellants were not apprised of their legal right provided under section 50 of the NDPS Act to refuse or to allow the police party to take their search, and in the event they agreed to a search, to opt for being searched before a gazetted officer or by a magistrate, the appellants would be entitled. No, the mandates of section 50 of the NDPS Act as interpreted in state of Punjab versus Baldev Singh, reported in 1999, 6 SCC 172, would not be fulfilled. The learned counsel has thereafter made reference to the order dated 27/2026 passed in bail application number 1722 of 2026 by this court to impress that when the notice under section 50 does not meet the requirement of law crystallized by the decision of the Honorable Apex Court in Suresh and others within bracket Supra, the petitioner would be entitled to the privilege of bail. The learned additional PP opposing the case has submitted that the notice itself contains the signature of the petitioner herein, to the effect that he had been informed and he had understood the notice of personal search under section 50 of the NDPS Act, and he had submitted that he did not require that his search be conducted in presence of the nearest gazetted officer or magistrate. He accordingly opposes the prayer for bail. I have gone through the material on records and also the citation relied upon by the counsel for the parties. In the present case, I find that the notice under section 50 of the NDPS Act did not inform the petitioner his legal right to refuse a search by the police party. Full stop. Keeping in view the law laid down by the apex court in Suresh within bracket Supra and the order dated 272026 in bail application number 1722 of 2026, I am of the considered opinion that in the present case, the petitioner requires to be enlarged on bail on furnishing sufficient surety for his participation in the trial. Stop. Accordingly, the accused petitioner, namely so-and-so, is allowed to go on bail of rupees 50,000 with one local surety of the like amount to the satisfaction of the learned special judge Shri Bhumi. Subject to the following conditions. He shall remain present during the trial proceedings as and when required to do so. He shall not hamper or tamper with the evidence, nor shall indulge in interacting with the prosecution witnesses. Full stop. In the order dated 272026, this court had also noticed as hereunder, from paragraph 11, from quote paragraph 11 and 12. This court is of the opinion that this order should also be brought to the notice of the whom? DG, who shall then percolate it to the different police stations. To the office of the Director General of Police. No. We are not going district wise. Let it go to the Director General of Police, who shall then thereafter percolate it to the different police stations under his jurisdiction. Let it be a one-time affair. Why should it go individually to each of the police? Should be forwarded, that a copy of this order should be forwarded to the Director General of Police, Assam, who shall in turn percolate the same to the different police stations under his jurisdiction. Full stop. A copy of this order would also be forwarded to the Director of Prosecution, Assam, for his doing the needful. Bail application stands disposed of. Get up ready to. Get up ready to. Yes.
Lordship, in this, the petitioner has been enlarged on bail on 25.
FSL, sir, FSL, have you got?
FSL is awaited. So
How do we know? He would have the FSL, sir.
that would have been very nice. If I could.
What happened? What happened actually? Tell us.
Actually, the allegation is by the sister-in-law. They entered into the victim and the petitioner entered into a love marriage. And after that, she died after 3 months of the marriage. And they have filed an FIR alleging that some suspicious circumstances and holding the husband, that is the petitioner, to be responsible. So
How did she die?
103,
What is the medical evidence? What does the medical say? She must have been admitted to a hospital.
hospital, page
Where
number
are the
59.
page number?
59 is the discharge.
Discharge.
Cause of death, sorry, cause of death.
59. It will be cardiac arrest.
Cardiac arrest to be ascertained.
Naturally, the heart has to stop before one dies.
Died.
What preceded is what we want to know. Acute liver injury.
Liver injury, hypoglycemia, and acute renal injury or sepsis.
So hypoglycemia would be when
Sugar
food is denied. Acute liver injury would be a hit to the liver. And renal injury, I do not know. But is she diabetic?
She was diabetic.
Okay. Yes.
No injury.
No? No poison, nothing.
No point.
Where is your
Yes, my lord. He himself taken to hospital, that is there. And vomiting and all this,
huh?
from some days, my lord, from one day, my lord, vomiting and something is, yes.
But what about page 37?
Otherwise, my lord,
Where is that MLC?
as per postmortem or.
No, please find out that MLC.
Hello?
Medical legal certificate.
Legal certificate subsequent to that, FSL, it is not available.
Huh? No, not subsequent to FSL. The first medical legal certificate.
Came to unconscious state.
You see on the ground of arrest,
My lord,
the attending doctor in the MLC submitted before district police station has opined the cause of death as homicidal.
But yes, when came to hospital, BP non-recordable state. BP was not there. My lord, ultimately,
No, MLC report, does it say anywhere? What am I asking? And what proof have you given to show that she was a diabetic?
She was diabetic. These are her medical documents which have been annexed here with annexure number 9 series. One day before the incident, she was having some vomiting tendency as well as other problems. She visited to a doctor and the doctor asked for her reports to go through this test.
So you, when a person is vomiting, you take her to
the doctor first.
the skin specialist.
No skin specialist.
Huh? Why did you take her to Dr. Roy, who's the skin specialist? Vomiting, not through the skin, hopefully.
Somnath Roy, Dr. Somnath Roy. He is a consultant physician and cardiovitologist.
Okay.
The left
So
hand
there are
side,
two doctors.
page number 45.
Somnath Roy, okay.
Somnath Roy. Somnath Roy was attending.
Results.
So later on the next day, after the reports came in, the doctor advised her to get admitted in the hospital.
Yes, sir.
Page number 48.
Page number 48, random sugar is high, SGPT is high, potassium is high, so will lead to a cardiac arrest. Albumin 2.9, meaning that the kidney is failing. We'll allow it.
otherwise also,
Heard.
A.I. Ahmed. A.I. Ahmed.
Yeah, Ahmed, learned counsel appearing for the petitioner also heard Mr. K.K. Parashar, learned APP, full stop. The case diary called for has been received along with the FSL report. FSL report is along with the FSL report, full stop. The learned counsel for the petitioner has submitted that the deceased wife of the petitioner was suffering from severe diabetes prior to her death, and on the unfortunate day the wife of the petitioner had to be taken to the hospital in a very precarious condition where she breathed her last, full stop. The learned counsel for the petitioner submitted that although initially there is a noting in the MLC as reflected in the ground of notice that the attending doctor had opined the cause of death to be poisoning, there is no such act done by either the petitioner or his family members on the deceased wife, and she had died of natural causes arising out of her severe diabetes, full stop. The learned APP has submitted that the FSL report does not indicate any poisoning or other such action to have been taken upon the deceased prior to her death, and there are no injury marks available in the postmortem report also. Full stop. In the above circumstances, I am of the considered opinion that the petitioner, namely Sri so-and-so, who has been held in custody since
Lordship, he has been enlarged on bail by the order dated 25/6/2026.
the petitioner who was already enlarged on bail pursuant to orders of this court is not required to be further kept in custody. Full stop. Accordingly, the privilege of bail granted by the order dated 25/6/2026 to the petitioner stands made absolute. Bail application accordingly disposed of.
Deeply obliged.
Any observations made herein would not affect the trial of the petitioner, if it so commences.
May it please, Lordship. Lordship, item number 22 connected with item number 41, charges has been submitted.
So what do you want to do?
We may protect the appearance before the trial.
Just a minute. Accused number 1 is a married woman. Above mentioned accused eloped with my brother. Oh. Was there any interim protection in either of the two?
In item number 22, interim is there.
Then in item number 1, you take down. You are Mr.
I'm H.M. Patwari.
H.M. Patwari.
Yeah.
Heard Mr. H.M. Patwari, learned counsel appearing for the petition. This is an item 21, huh? An item 22. The learned APP, Mr. Parashar, has submitted that the investigation is culminated in a charge sheet, and the
White CS number.
white CS number
97/26, that is 307/26.
Full stop. The learned counsel for the petitioner prays for leave to what?
Yes, sir.
You will approach the trial court?
Yes, sir.
Prays for leave to approach the trial court. Full stop. Accordingly, this bail application is closed, allowing the petitioner to approach the learned trial court for appropriate remedies, if so advised. Stop.
Much obliged.
Then in 41, you take down. Heard Mr. So-and-so learned counsel appearing for the petitioner.
It was in interim or not, I don't know. 41 maybe.
Even if there's no interim order, we'll observe that after the. Oh no, there was an interim. Also heard Mr. K.K. Parashar, learned APP, full stop. The learned APP has submitted that the investigation has culminated in charge sheet number so-and-so agotwe, huh? Full stop. The petitioner had been allowed an interim protection by the order dated 16/6/2026. Full stop. Since the investigation has already culminated, there would be no further apprehension of arrest of the petitioner by the investigating authorities. Full stop. Accordingly, the anticipatory bail petition is closed. Petitioner would be at liberty to approach the learned trial court, praying for appropriate relief in the event she is put up for trial. AB disposed of.
Looks when the last medical report was called for. So there have been
That medical report not yet received, but otherwise, my lord, on perusal of the 183 statement, she is clearly implicated, my lord.
What is the allegation, sir? Can we have the allegation?
allegation of coke.
14 years old girl, my lord.
You are appearing
No
for
such
the,
thing.
okay. To beg us,
No incident happened, Lordship.
yes. You are for the accused number, what?
Allusion, accused number one.
1, 2, or 3? You are for accused number?
One.
1.
In the FIR.
Hmm.
14 years around 11 months, my lord.
Huh?
Age of the girl.
I'm behind the bar for last 60 days, Lordship.
60 days.
Lordship. So medical may be looked into, Lordship.
Huh?
No incident happened, Lordship. Definitely, court will not find anything in the medical report, Lordship.
How come there is no medical report? The CD does not contain medical report. The victim has not been sent. And people have been arrested. The first thing they do is send a minor to medical. Where is the report? Yes, were you taken to medical? Are you appointed by the court or are you appearing for the respondent number 2? Were you taken to medical?
Medical, yes. Not
You have no idea. Then why are you standing for the respondent number 2 to do what? It's a POCSO case, please don't give bail.
Yeah,
Give us something more.
Medical slips are, advice slip and medical slips are there, my lord.
Please show. If you are unable to read, we will read it.
16-6, yes. Incident of 16, yes.
Incident is of when?
16-6.
Show us what is the medical advice.
Accident of 14-6. Medical, it was slip of 16-6.
She must have been sent for medical examination by a proper doctor to find out whether there is any injury, whether there is any sexual activity, recent sexual activity, whether she is under intoxication. What does the radiological test say?
Report is not there.
Nothing in the CD.
No, my lord, the report is not there, my lord.
If the report is not here, then we shall have that person here who is investigating the offense. Keeping everybody behind bars, then not being able to defend it.
I don't know, there is this, only this part.
Incident is of where? 14.
14-6. FIR of 15-6.
My wife stays separately, my lord. Thereafter, my lord, I am in love with this victim, my lord, and she herself eloped with the petitioner, my lord. And my lord, after that, my lord, the mother was, my lord, the victim's mother lost this affair, my lord. She was against the marriage because of the petitioner.
Already eloped with you.
My lord.
When?
My
On?
lord, eloped, my lord, long back, my lord. She is
On?
my lord, in the FIR, my lord.
Forget the FIR. It is your.
I have mentioned, my lord. Petition in the month of August 2025, my lord.
In the month of August 2025. When did she return home?
My lord, after, my lord, near about a year, my lord, she returned.
That is, she returned in August 2026.
My lord.
Until such time, the mother did not lodge an FIR. Only when she returned back, the mother lodged an FIR.
And when, my lord, after return, my lord, she's instigating, my lord, every time, my lord, to the victim, my lord, to return back.
What I am saying is the moment you eloped, she eloped with you.
My lord.
Mother did not lodge the FIR.
No, my lord.
She was happy.
Happy.
When the daughter comes back, the mother becomes sad.
My lord, always mother told her, my lord, but she is not agree to with her mother, my lord. But subsequently, my lord, when she returned back, my lord,
Hmm.
the mother lost the affair, my lord.
Yes, sir. What do you say?
My lord, here, after dismissal, my lord, fully just submitted charge sheet, my lord. Here, trial is going on, my lord. Here, next date is, my lord, OPN consideration of charge, my lord. Charge is
Concern,
not yet
please,
done,
your
my
concern.
lord. And
What is your statement?
here, 183, my lord, 180 statement are there, my lord.
What does it indicate?
My lord.
164,
5 months pregnant at that time. Also.
That is not an issue.
164, my lord, kindly see, my lordship.
Huh?
164 statement possibly she is.
He insists on
My
183.
lord, 180, first one.
He insists on 183. You are
Yes, my
insisting
lord.
on 164.
There is some contradiction, my lord. 100 days, my lord, in custody, my lord. Local person. You will face the trial, my lord.
And any seizure of birth certificate or something, sir?
No, at present, no.
Huh? No seizure.
Birth certificate, my lord, not.
Huh? Birth certificate, anything? How do you?
Herself, fill up with the petition, my lord.
Yes, madam, what do you say? Have you seen the 183?
Yes, Your Lordship.
Yes, tell us.
Lordship, she's 17 years. So
True.
there might be a possibility of love relationship, Your Lordship.
Little difference in the statement before the police and the this thing. He মোক ফুচলাই লৈ যায় আৰু মতালত পলাই যাওঁ. Ultimately,
Same thing. My lord, my submission is that, my lord, at least victim may be examined, my lord.
My lord,
Here, consideration of charge, my lord. If they are, my lord, they also pay there for discharge, my lord. Even if, my lord, at least victim may be examined, my lord. In such type of pokcho cases, my lord.
my lord, already 100 days, my lord.
At least
He-
Condition may be given, my lord.
she would not at least retract from saying that I'm pregnant.
my lord.
You do not have anything on record to show what is the age.
No.
17 plus 2,
19. So, yes,
finished.
aforesaid.
But they may also argue at the discharge, my lord, at the consideration of charge. Charge is not yet framed, my lord.
Maybe, but
Already 100 days, my lord.
At least victim may be examined, my lord. Otherwise, there may be some, my lord, empower on against my lord.
Is the condition may be imposed, my lord.
keeping him behind bars is not helping. Charges are not framed till now.
Not framed.
Then there will be no question of a discharge when she keeps on saying I'm 17 years old. That option is gone. Trial is going to start.
My lord.
And he remains behind. How does it help? Tell us. She has not expressed any apprehension. But what apprehension would be there? The apprehension is with the mother who would now make her change her statement. Say that you were raped. You have to say that you are raped. Is it not? Hey, video to officer ne? Huh? The mother has now to force her. She's already with the accused. Is there a specific bar on this that we cannot consider the bail?
No, my lord, no such specific bar.
In the circumstances given,
My lord, but
it will only be the satisfaction of with a fresh petition.
Can it be,
Huh?
Lordship, can it be, call for another day? Up to date case there may be call for.
Whatever is there, we
So
are.
my lordship, then I have some respectful submission, my lordship. Your lordship, two things, my lordship. I'm sorry, my lordship, for repeating the line. A lordship may see the what are the incremental and what is the source of the incremental. First thing, and second thing, in the jail, they loss of it. I was not in the jail. The two name is mentioned in them. And my learned friend only submission, as far as I understand, co-accused mentioned my name, my lordship. That's a part of this. And I've already said that they're getting now judgment, a lordship, aware of it. That co-accused statement is not a substantive evidence. I've said, my lordship, that CCTV footage is there. In CCTV footage, my face could be identified more as there on my lordship. So, lordship, 39 days, my lordship, and I have been. It is mentioned in the FIR. CCTV footage is there, my lordship.
But then in your forwarding,
My lordship.
it is written that it will be revealed from the CCTV recording. When the CCTV is taken away from where we.
They have said they have recorded from there. They have taken it.
Or they have taken the CCTV, the record, okay.
My lordship, kindly come to page number 22, my lordship.
22.
Who pay, my lordship? In the FIR, my lordship, that the set in my lord. Well,
Yes.
Kindly come to page number 22, my lordship. Paragraph 6, my lordship, that the said incident is supported by CCTV footage and some of the miscreant may be identified from the recordings and witness present at the spot, my lordship. It's FIR mentioned CCTV footage is there, my lordship. Kindly come to page number 22, my lordship.
We've seen.
That is the CCTV footage. FIR informant complainant himself mentioned the CCTV footage is there. From there, it can be identified, my lordship.
We can have it this way, sir. Either we close it today.
My lord.
With your liberty to come back after investigation has proceeded some more.
My humble prayer is that 39 days and may not be. And my learned friend so far, whatever I understood, only thing, two things says my lordship. And my lordship, 39 days period, my lordship, whatever the investigation need to be carried out, my
But
lordship, further.
You are Mr. R.
Amin, my lordship.
Mr. R. Amin, learned counsel appearing for the petitioner, also heard Mr. Goswami, learned APP. Full stop. This is a petition under section 483 of the BNSS, praying for grant of regular bail to the accused petitioner, namely Mr. Shubhankar Kaur, who was arrested on 12/7/2026 in connection with Borpeta PS case number, page 1 of the The learned counsel for the petitioner has submitted that the petitioner has spent 39 days in custody and further custodial interrogation with in regard to the aforesaid case may not be necessary, and therefore the petitioner would be entitled to the privilege of bail. Full stop. The learned APP has submitted that the case diary has been received and sufficient materials are there to implicate the petitioner in the commission of the offences. Full stop. The learned APP has submitted that further detention of the petitioner is required since an interested gang is being traced out and release of the petitioner on bail at this stage may hamper the investigation process. I have gone through. And also and may hamper the investigation of the case and also hamper the recovery of the looted items. Full stop. I have heard the learned counsel for the parties. I have also produced the case diary. I have also considered the contents of the case diary. Full stop. In my considered opinion, the petitioner would not be entitled to the grant of bail at this stage. Accordingly, the bail application is rejected. We are saying at this stage, you can come back after some days.
Deeply obliged, my lord.
Lordship,
Number 2.
Section 12 is there, my lord.
Number 2, anybody?
But we are waiting for the report, my lord.
Where? From where?
Karupitial police station, my lord.
From Karupiti, it takes so long. What is the age of the petitioner?
Petitioner is lordship
27 years. Hmm. And when was he arrested?
Victim, my lord, 14 years.
1/6, my lord.
Huh?
1/6.
1/6.
Yes. He's facing the trial, lordship.
Huh?
He's facing the trial, lordship.
He's facing trial.
Under trial.
162026, he was arrested.
Yes, my lord.
1/6.
1/6/2020.
Trial has started.
Under trial matter, yes, my lord.
Then I think we can await the outcome of the trial.
Lordship, yes.
Huh? Should we await the outcome of the trial?
Well, section 12 is there, my lord.
Hmm.
Law will take its own course, my lord.
I think we should allow it to happen.
But he's married man, my lord. It is
More the reason he should not be roaming in the
lordship.
society.
Lordship.
Not because he's married, but because he's going to do offenses even after being married.
Offense, my lord, as per my lord, a statement recorded by the police, my lord, the contradiction is there. Once the girl said that he caught my hand. From 183, the materials developed, lordship. Another thing, implications. Just for it.
When
My lord,
service of notice?
31st.
31st of August, service of notice on the respondent number 2. Let them be here.
Obliged.
কিমান থাকি গ'ল? Hmm? Add 2.
Sir.
Add 2. Hmm.
May please, Lord. Regular bail application, my lord, petitioner behind the bar 128 days, 123 days to do.
My lord, service report awaited.
Borpeta.
My lord.
Borpeta, my lord. The case is absolutely false case has been lost, my lord. Victim is examined, my lord. Informant also examined, my lord. Kindly see the statement of victim, my lord. Page number 26. Page number 26, my lord. From the evidence of the victim, my lord, POCSO is not attraction. They have love affairs on the date of occurrence. They talk to each other. Then uncle came and apprehend the petitioner, my lord. This is the case, my lord.
No.
Now POCSO is not attracted, so my lord. Other section also not attracted.
When the service report come.
Have you seen 26?
Page 26.
What remains?
123 days today, my lord.
Let the service report come, my lord, because earlier is plus.
When? Huh?
If
When?
POCSO is not attracted, then why service need to notice, my lord? It is in the allegation in the affair, POCSO is there. But from the evidence of the victim, my lord, it appears that there is nothing.
এখন দেখুন। এই নোটিফিকেশনখন উলিয়াওকচোন এই বেইল কনচিডাৰেশ্যনৰ পক্সো কেছত বেইল কনচিডাৰেশ্যনৰ যে নোটিছটো দিব লাগে নোটিফিকেশনখন দিয়কচোন।
Dipok na.
Notification.
The 183 would be here. Hmm?
180 is 17 minutes.
Have you seen the 183? No. Ah. Thousand eight. Hmm? 2008 to 2026.
Hello.
How many years? 18. Monday. Huh? Monday. List again on human right কৰিব 24th awaiting service report. Will stop. The counsel for the petitioner has drawn attention of the court to the evidence of the alleged victim recorded during the trial and has submitted that the offenses alleged under POCSO are not made out. Stop. On Monday.
Here in this case, Lordship, non-furnishing the grounds of arrest to the relative, Lordship. But
Hmm.
Your Lordship will find page 48.
Page
48.
Ah, yes.
Public prosecutor was supposed to.
What is the report? Yesterday we had this case. No, day before yesterday, huh? Yes, what is the report? What does it say? Otherwise,
That notice was, and that information was given to the local people, local head of that locality, because that is a disturbance area. And at that time that some conflict in Manipur was going on. So that OC concern, that OC concern has informed him on the phone number is also there on that phone, in that phone number.
Yes, what do you say?
Regarding telephonically communication.
No, no, exceptional circumstances.
But your lordship has already.
Could
dealt
not
with
be
this
served
issue.
in, could not be served in person due to the ethnic conflict.
That your lordship has already that dealt with in Nawaz Sharif's case, lordship. In that case also similar situation was there.
Nawaz Sharif.
Nawaz Sharif, yes. Earlier, his earlier bail application was rejected on that ground. Subsequently, your lordship dealt with and was released on bail, lordship. He was also from Manipur. Similar situation was there.
Here that ground was not there.
That earlier rejection order I am giving,
Where?
that is gone, lordship. It is possibly grandfather of the.
এই সেইখন দিয়কচোন এইটো ৰেকৰ্ডটো কল কৰকচোন 477 of 2026 PA 477 of 2026
Earlier also we discussed in bail application 477 of the 26. Here also in this case also that
এইটো ৰেকৰ্ডটো
WT
বুজাই আনকচোন 477 of 2026 হা
WT message sent from Delhi to that local authority station, and nothing thereafter nothing communication was there. But here we have that communication that from that concern there from this police Karimganj to that concern, and they have informed us that we have informed this person in this phone number because of that disturbance we could not go directly with it. So there was some development is there in this case also. This is not that in earlier case.
no we are on a different thing. Earlier in bail application 3301 of 2025, in the same case, Nawaz Sharif, this court had said that 48 compliance cannot be there because of the ethnic riots. Apparently, this next order that I had passed, it says that since it has not been served, I'm granting bail.
Honorable Mr. Justice, Sanjeev Sharma sir.
He rejected it and I allowed it.
And in division
5-2 and 18-3. So I need that earlier record to see whether this was a part of that.
And the division bench order where lordship bail was granted, that person was also from Manipur. There also plea was taken that it was telephonically informed. That was not said sufficient compliance. That division bench order, lordship. Here also plea of the that paragraph 4, lordship may kindly see. They have informed that telephonically and through WhatsApp, relatives were informed. But the division bench said that it has to be in writing, lordship. Even belatedly, but it has to be in writing. Paragraph 4, submission of the respondent counsel, appellant's counsel.
No, it doesn't say so.
But here, lordship will find the chief in this paragraph 4, lordship.
No, show us the finding of the court.
Finding of the court, your lordship will find paragraph 16. After that, Darshan Lordship, however, the grounds of arrest have to be furnished within a reasonable time. In the present case, the accused respondent was arrested on 19/5/2025, and till the date of filing of the written objection by the appellant in bail application number so and so, the brother relative of the accused respondent had not been provided a copy of the grounds of arrest. This delay of approximately 18 days, in our view, is beyond reasonable time, keeping it with us. And in my case, today also, it's still today not furnished. Lordship.
কি দিছে ৰেকৰ্ডটো লাগে মোক হেৰিটো নালাগে অৰ্ডাৰটোতো মোৰ হাতত আছে কাৰণে হাততে পাইছো অৰ্ডাৰটো ৰেকৰ্ডটো লাগে is telephonically in this particular case is not from here but from that.
In submission, Lordship, that through WhatsApp it was acknowledged, but that is there at paragraph 4. And paragraph 8 also says that he was informed, relatives were informed about the arrest.
Just a minute. The brother had acknowledged a receipt of information regarding arrest and ground of arrest. First time so no records had been produced before the show the grounds of arrest.
And paragraph 8 also relevant.
There was a total confusion in this case. When the matter was before the special judge, the stand was that the father had been informed about the arrest. Therefore, the special judge granted bail saying that the grounds of arrest had not been communicated to the brother. Second time, before the division bench, the stand was taken that the brother of the accused had acknowledged the receipt of the information. Then,
And here also
court held
Lordship,
that the communication of the grounds of arrest of the accused to the respondent had not been communicated to the family members.
and here also
Not discuss what has happened with the brother. There is nothing to prove that the grounds of arrest had been received by the brother of the accused respondent on 25/2025.
here also my case is same, and in fact, the communication which has been placed before the court today, Lordship, if your Lordship peruses, here also written information regarding arrest and judicial custody. Here not said that the grounds of arrest were communicated. In the second line, your Lordship will find, and Bihan Kumar, that is paragraph 32, it is clear that the grounds of arrest and intimation of arrest, that is two different aspects.
The facts of the case.
I'm sorry, this is the paragraph 26 of Bihan Kumar, not 32. Paragraph 26, not 32. I have said paragraph 32 of Bihan Kumar. Paragraph
that's all right.
26, it is clearly seen.
When were you arrested?
I was arrested on Lordship, 27/8/25. 28/8/2025 forwarded.
No, but there was, on that particular point of time, the ground of arrest could not have been served because of the ongoing tension. What happened after that? 1 year has gone. Any attempt to serve the grounds of notice on them, grounds of arrest on them?
That instruction I do not have, but
Hmm?
that instruction I do not have, but probably they're not because of at that time they have informed it and
When you have half-baked cakes, you should expect a throw away, huh? When the cake is half-baked. Where is that notice? Which they
Page
say was
48.
sent?
Page 48.
Page 48. 28/8/2025, huh? Yes, your today's information show only the intimation had been given. No grounds. Doesn't say the grounds had been forwarded. How did you send it by WT?
WT.
How was it sent?
WT is through WT message.
Huh?
The WT message it was sent us.
And who was the witness during the arrest?
No witness signature is there. Page 47.
Eh? Page 47.
Lordship.
How many petitioners?
One petitioner before your Lordship.
2 were arrested.
Okay. 4 persons were arrested.
Huh.
One is before your Lordship.
What has happened to the others?
Others, probably they are
Not
inside.
known.
They are inside.
Ah, yes. What about page 47, sir?
Lordship.
Any earlier bail petition by these people?
No. Before sessions court, it was pleaded that 48 notice is not served. So it is only said that it was sent to concerned peers, that subsequent proceeding is not recorded. Lordship. That page 45 starts from page 45. That
Yes.
even then the notice was not served.
What about the Arrest memo?
Arrest memo, Lordship. In arrest memo, Lordship, that signature of the witnesses, Lordship, it may not be there, Lordship, because Lordship, in some cases, Lordship, when, because if that the others parts are complied with.
Which part?
That 47, 48 and others are.
Huh? Which part if complied with? Which part has been complied with? He was driving a vehicle, you catch hold of him, you have got the witnesses of the seizure. And when you arrest him, you don't have a witness. Whether he was in the car, not in the car, whether he was in the station, not in the station. Record to খুঁজে আছে তো আহি পোৱা নাই heard Mr. A. Ahmed, learned counsel appearing for the petitioner, also heard the learned APP. By the order dated 18/8/2026, the learned APP was required to place before this court relevant documents, and to place before this court the documents to show the service of notice issued under section 48 upon the family, friend or relative of the petitioner. Full stop. The learned APP has submitted before this court a WT message. This is a message. Don't say WT. Say has formed, has placed before this court a message from the officer in charge of the Molcham Police Station, Chandel District, Manipur, where it has been stated that the information regarding the arrest/judicial custody of the petitioner had been duly communicated telephonically on the 1st of September 2025 to the father. What is the petitioner's name?
Dongle Nongkumang Hoki. So this lordship communication also pertains to another accused, not the present petitioner.
Huh?
Oh yes, it is there. And Dongle. And Dongle.
They're what? Brothers, sisters, or what? Brothers, or what?
No, different person. Two person. His name is also there, Lord. Yes.
Had been communicated to the father of the other co-accused for both the families. Can it be done?
No, no, sir. This is not Lordship. This is the Lordship. This communication was given to that last two lines, about 2 lines, Lordship.
Huh?
Chief of that local head of that locality, he has been informed also.
It was given to T. Chungnambam Haikop, father of so-and-so, chief of Bangmol Tampak, for both families. It is not given to the chief to send it to the both the families. It is given to the father of one of them for both the families. Can it be?
In that case, Lordship, that part will also come, whom he has been nominated, Lordship, that
Huh?
whom he has been nominated, that part will also come also. Yes, Lordship.
We have given you ideas. The ideas are not here. What to do? In the earlier order, one coordinate bench had to say that please inform this to the SP for modification of the notice. Can we go to that extent all the time? Will we not lose our fairness if we do it all the time? Huh? I say, telephonically to ইয়াত আছে এইখনত আছে হা চাই ল'ব টু so and so মই পেন্সিলে দি আনলাইন কৰাটো for both the families full stop. The learned counsel for the petitioner has submitted that apart from the fact that the arrest memo does not contain the signature of any of the witnesses to the arrest, supplying of information regarding arrest and judicial custody to the father of one of the co-accused for both the families will not suffice the requirements of section of service of section notice of under section 48 of the BNSS full stop. Accordingly, he submits that the arrest of the petitioner and the further detention has been rendered illegal and the petitioner requires to be released on bail. Full stop. The learned APP has submitted that the mere absence of the signature of a witness on the arrest memo would not be enough to entitle the petitioner to the privilege of bail, and further, it is on record that due to the ongoing ethnic conflict in Manipur at the relevant point of time, the officer in charge of the concerned police station could serve the intimation upon the father of only one of the accused for both the families. Accordingly, he says that the provisions of law insofar as the service of notice under section 48 of the BNSS is concerned, there is no violation and therefore the petitioner would not be entitled to the privilege of bail at this stage. Full stop. I have gone through the records placed before me and the judgments referred to. Full stop. The absence of the witness to the arrest as depicted in the arrest memo under section 36 of the BNSS, coupled with the fact that the intimation regarding the arrest had been given to the father of one of the accused, not being the present petitioner, and there being no assertion that the grounds of arrest had been served upon the family, friend, or relative of the petitioner, this court is of the considered opinion that the arrest and the further detention of the petitioner pursuant to the said arrest has been rendered illegal. However, this court notices that the petitioner is facing trial. He's facing trial now. He's facing trial and is a permanent resident of a locality beyond the jurisdiction of the trial court. In such circumstances, this court is of the opinion that the petitioner would be entitled to the privilege of bail since his arrest has been rendered illegal. Arrest and detention has been rendered illegal, and therefore it is directed that the accused applicant be released on bail on furnishing a bond of ₹1 lakh with 2 sureties of the like amount to the satisfaction of the special judge Sri Bhumi, subject to the following condition. ইয়াতে খালি এই ইয়াৰ পৰা কন্ডিশন গিটা দি দিব, এইগিটা চেক কৰি ল'ব হা, NDPS কেস নাম্বাৰ আন্ডাৰ কি হা, এটা জায়গাত এইটো কাৰেক্টলি বহাই দিব, the accused applicant নেম দি নামটো দি দিব, ইয়াতে ভৰাই দিছো।
He is from Manipur, Lordship. Lordship has probably ordered that he is from the residence of that locality of trial.
He is not from, he is a permanent resident of a territory beyond the jurisdiction Kosunema. He is and the accused is a permanent resident of a locality beyond the territorial jurisdiction of the learned trial court. Sentence to the All right. What is it? Teacher, I'm more here to do.
Obliged.
Yes. Next.
Please, Your Lordship. My lord, the petitioner were arrested on 22 of July, my lord. Today is 30 days behind the bar. FIR is faced 10, my lord. FIR lost against my lord 3 persons. And the petitioner before your lordship from the FIR 2 and 3, not for the accused number 1, my lord. The FIR, my lord, filed the informant and saying that the informant and FIR name accused number 1, they're the classmate, my lord.
Informant and accused number 1.
Yes, my lord. I'm not for accused number 1 here. Informant and the accused number 1 is the classmate. And the informant opened a bank, my lord, bank account on 17th of July because for transaction of money. And thereafter, my lord, the account was active on 18 July. And thereafter, on 20 July, at about 10 a.m., the accused number 1, that is his classmate so-and-so, he came to him and asked him that I want to treat you how to execute how to use the checkbook and your ATM because you newly opened the account. And saying that due to my friend's KYC problem, he cannot transfer the money. So in your account, one of my friend will deposit some amount.
Carrier of a carrier.
Yes, my lord. Thereafter, my lord, he gave the
Double carrier.
Yes, my lord. Thereafter, he gave the ATM and checkbook to the accused number 1. And my lord, evening he got a message, my lord, that some money is deposited in his account.
That is all right. Tell us why we should leave you on bail. Why we should grant you the bail. You are accused number 1.
No, my lord.
You are accused number?
Accused number 2 and 3. 2 and 3 is nothing, my lord, in the FIR.
2 and 3 are the persons who
They are the
main person, my lord. They have engaged him, my lord.
you had enticed a double carrier.
Collect the, my lord.
You have the CD.
My lord.
As per my lord, the FIR, I am submitting, my lord. Then on next day, 21st of January, my lord, July, my lord, the accused number 1 in the FIR, his friend, and they took this present petitioner also in a vehicle and asked him, we will go to the withdraw the money in Goalpara branch of Axis Bank. And they went to the Goalpara. And the Axis Bank found some server problem. They again returned to the original bank, that is Dubdara branch. And when Dubdara came, the present 2 petitioners, they were sitting in the vehicle. And the informant and the accused number 1 went to the office.
What is their role? What is their role?
The present 2 petitioner, they are the main person, my lord. They have engaged the, my lord, petitioner, my lord, accused number 1, my lord, the FIR, my lord, to collect different bank passbook, ATM, etc. So that can be used for that.
I am submitting, my lord.
No, here materials are
no, I am ruling. What is the role of the accused number 1, my lord? Because
accused number 1 asked him to let him use the bank account.
My lord, only accused number 1 asked us to go as visiting with him. Therefore, we do not know the fact, my lord. We came with him.
Where is the accused number 1? Under arrest? He has been arrested.
He fled away.
Well, his statements are here, man.
His statements are here.
And my lord,
but from the bank, my lord, he fled away. In the meantime, my lord, when bank found that the money has come from my lord, cyber, then bank authority called the police, my lord. But the present petitioner is not aware what happened in the bank. They are sitting in the vehicle, and immediately that original boy, my lord, he is accused number 1, he fled away. Now the police has come and police caught us, my lord. And police asked us when we could not disclose the fact of what was in the story, my lord.
Are you so free that one of your friends says that my other friend will draw money from the ATM. Let us all accompany him from Gwalpara to Dhupdara and Dudnoi.
Actually, my lord,
And you keep on going around with them for
Actually,
no
my lord,
reason whatsoever.
initially, my lord, this purpose was not disclosed, my lord. About the bank purpose was not disclosed. They're young boy, my lord, similar age, my lord. They
24
want
years,
to move.
25 years, others are studying and trying to make a living and they're roaming about in a Maruti
My
van.
lord,
looking around.
in the FIR, my lord, nowhere mentioned. Nowhere mentioned.
You are not even using your own account.
My lord.
You are
Yes.
putting other people in trouble.
From the
The
account-
student
Yes,
who would
ma'am.
require some money from his house to buy books or something,
Yes,
his scholarships will come in that account. Now it is frozen.
that's right.
Then heard. Mr. Ainuddin, learned counsel appearing for the petitioner, also heard the learned APP. The present is an application praying for grant of bail to the petitioner who has been taken into custody on, when were you taken into custody? 22/7/2026 in connection with Dudnoi PS case number 41 of 2026.
22/7.
According to the FIR lodged by a student, the accused number 1 as named in the FIR had sought his permission to use his bank account since one of the friend of the accused number 1 was having a KYC problem, full stop. It later appeared that the bank account of the petitioner of the informant had been used for making fraudulent transactions, and the account of the student had been blocked by the National Cybercrime Reporting Portal. Full stop. The accused number 2 and accused number 3 in the FIR are before this court praying for grant of regular bail. Full stop. The learned counsel for the petitioner has submitted that the petitioners are not involved in the defrauding process or the use of the bank account, and therefore they may be enlarged on bail. Full stop. The learned PP has submitted that the investigation so far, as revealed in the CD, have implicated the present petitioners, and there are sufficient materials against the present petitioners to indicate that they were the persons who were responsible for the fraudulent transaction, etc. Full stop. I have heard the learned counsel for the parties, and I have also considered the contents of the case diary. Full stop. At this stage, I am not inclined to grant bail to the petitioners. Full stop. Accordingly, the bail application is dismissed. We use the word at this stage. If it is some solace.
They are also taken to the Delhi and Haryana for that type of offenses.
Huh?
For such type of offenses, they are taken to Delhi and Haryana to train up these 2 persons.
Then also, no one should be allowing others to use their bank accounts for, if there is a KYC problem, that bank account is itself doubtful. Yes, service report on the respondent number 2. Service report respondent number 2. Gorchuk.
No, not received.
Lordship,
Fakirganj.
Section 36/47.
Gorchuk, yes, huh?
Section 36/47/48 violated, Lordship. That is
All of them?
all of them, Lordship. Lordship, may kindly come to page 23, Lord, 22.
Page 22. Okay.
Page 22,
Huh?
47 notice.
Ah.
Lordship, grounds of arrest were not communicated in Assamese, Lordship. His signature is in Assamese. This is my first ground. Secondly, Lordship, 48 notice. Next page, Lordship. 48 notice was given to a right thumb impression of Monwara Khatun, Lordship. And Lordship, next page, arrest memo. Independent signature of relative friend. Right thumb impression of Monwara Khatun. Who is Monwara Khatun, Lordship? May kindly come to page 11 is the FIR. She is the complainant, Lordship.
Name and address of the arrested person, Sahidul Ali.
Yes, Lordship.
Monwara Khatun, wife of Sahidul Ali.
Lordship. She is the informant.
She is very much angry with you for committing acts under the POCSO.
POCSO Act, my lord.
But she remains your wife, who also loves you enough to say that, okay, I will take enough steps to
Lordship.
see that you are not punished for it.
How can I nominate her, Lordship?
How do we know whom you have nominated?
Lordship, it is.
Yes, sir. How can the informant be a witness to the arrest and also be served with the grounds of arrest? Where is the FIR?
FIR at page 11, Lordship.
In the FIR, it is said.
FIR was filed after 1 month of the alleged incident, Lordship. There was some matrimonial dispute, Lordship. After that, she was my second wife, Lordship. She stay in Guwahati. My first wife stay in village, Lordship. So,
Your first wife stays in the village,
Lordship.
and you are her second husband.
Lordship. She is my second wife, and her first husband also died, Lordship. After that, I married her. And the
Now,
alleged victim girl is the daughter of her, Lordship. Allegation of POCSO is there, Lordship. I am behind since 400 and Lordship 8 days.
Now, you have given the notice to the informant who has said in the FIR, Gotike Doyamlu Muhudoye Todonto Kori, Ubevostha diyejen.
ইতি আপনার বিশ্বাস
You are giving the grounds of arrest to the informant.
Lordship. That is my case, Lordship. And in 47 also, in Bihan Kumar, Lordship, it is very much clear that in Assamese language, Lordship, in regional language, must be grounds of arrest must be provided, Lordship. That is also there in Bihan Kumar judgment.
Well, the record also not received to the record.
What record?
Lordship, I have certified copy if you, Lordship.
Official balance sheet, my lord.
PCR. TCI is not received, it is fine, but as
I
a
have
officer of
certified
the court,
copy.
perhaps
Lordship can rely on certified copy.
would we disbelieve the 47 notice, the 48 notice? Can we disbelieve that? The arrest memo.
Lordship, 408 days in.
The only thing which is disturbing us is you are giving it to the informant.
She cannot become an independent person, Lordship. She cannot, she is an interested person. In
Whole of India is independent, sir. He is an independent person. She cannot be an independent witness, maybe.
Witness, Lordship, Lordship.
More দ্বিতীয় স্বামী
Yes.
সোহেল আলী আমি থাকা
We are not on there.
my lord. Informant.
He is the informant. The problem is she is the informant. You are telling her that we have arrested your husband. This is the ground of arrest. Help him. Do we need any further documents unless you say that these are false documents?
No, that
Cannot be. This has to go. This has to go.
my lord. No, I cannot say, my lord. These documents are false, my lord.
And see, for the last 1 year, no one noticed it.
My lord. He has rightly pointed out today.
He has pointed it.
After a long time.
408
days, Lord.
408 days.
Kind of, yeah.
So do we need to send notices, await service report on the respondent number 2 or not from Jalukbari?
After 408 days,
Okay,
Lordship.
we'll do it this way. We'll keep it on Monday.
Tuesday, my lord.
Huh?
Monday, several cases.
No. We'll dictate the entire order today itself.
My lord.
We'll keep it on Monday. We'll appoint an amicus. The protection of the victim under the POCSO is one part of it.
Right.
And when there is total violation, it is constitutional right being violated. Is it not? How far has the trial proceeded?
Trial
Can you
is
find
going
out?
on, Lordship. Victim has also examined, Lordship.
Victim is also examined.
Examined, Lordship.
If that person is being defended by an advocate, same day or few 1 or 2 days, and if you being not be there, still will be arrested.
Huh?
Will be arrested.
The arrest itself goes. Once the arrest memo is signed by the informant itself, arrest is illegal. Huh? Which other part? That is what tell us. The prejudice that is demonstrated, sir, in this case is his wife is given all his documents.
On the same day, but in the Hancock judgment, the last part was which is said that notice is required to give only to
Enable him to defend. Correct.
He already giving and by an advocate on the day, same day, suppose may not be here in on the same day, then that article 22, 21 is being complied.
No.
If article 22.
The moment his friend or relative is not being given that particular document, Vihan Kumar or some other judgment, it also says that why do you need to give the grounds of arrest? So that they know how to defend it. The arrested person is already behind bars. Give him all the notices you want. He will not be able to take up an advocate, discuss with him and have himself fully defended. That is why the notice to the relatives. Now that relative is his wife, who is the informant.
Even this notice.
In this now let us concentrate on this case. It has been given to the informant. Now what happens?
Same day, if on the sometimes it happens on the same day he is being represented by one counsel.
Who will of course be engaged under his wakalatnama. But the entire issue of giving a notice under section 48 is for what? So that his relatives can convey to the advocate that this is the reason why he has been arrested. Please defend him. Yes? That is not there in this case. It is with his wife.
Get advocate on the same day, then that's the purpose of that Vihan Kumar.
To us in Vihan Kumar that if he is represented by an advocate on the same day, then 48 need not be complied with. Yes. We'll have it after half an hour. Show us that sentence. Yes. Next.
I can ask 36. May I please?
Huh?
Petitioner is an interim lordship, appear before the IO lordship and all.
CD not received, my lord, they are interim, my lord.
Lordship, today is a 5th date lordship.
See, from April 2026, your persons are not able to produce a CD. Why?
This is a Hazo lordship, hardly 1.5, Hazo PS lordship.
Why the user CD not coming?
5 date lordship.
Requisition also sent on 12/8, my lord. From our office.
24/4, 18/5, 17/6. What is the allegation against you?
Allegation, this petitioner is the owner of the vehicle. The oriental, his vehicle was used for carrying cattle, 20 number of cattle lordship. And the present vehicle which is used in the for cattle, this is a livestock body type lordship. This is a vehicle is a livestock body type, body lordship.
Livestock body.
Lordship. That is page 9. I have annexed the lordship. That is page 19 lordship. This is a certificate issued by the veterinary officer.
Where is it? Page 19.
19 lordship. This is a certificate issued by the veterinary officer that the body is livestock body lordship. Carrying.
Yes.
And present
Which could carry 16 cattle, you are carrying 21.
Because lordship, here is the cattle up to 20 kg. Up to if per cattle 20 kg, then he can carry it. Lordship, this is a table lordship.
20 kg, no, it's 200 kg.
200, sorry, 200 kg. If the per cattle 200, then 16 cattle can carry. If cattle are below 200 kg, then more cattle can be carried.
No. Up to 200 kg. Even if you have one cattle of 10 kg, Still, still not more than 60.
200 kg, up to 200 kg.
With cattle weighing up to 200 kg.
Yes, up to
Whatever be the
200
weight.
kg, 16 cattle can carry, Lordship.
Huh.
But in this case,
You
Lordship,
carried 21.
here in this present petitioner, Lordship, he is a owner, Lordship. He is not present at the time of when cattle was loaded, Lordship.
Why? Why not?
Lordship, because he sent a vehicle to load the cattle through his driver, Lordship, and he was not generally not present at that time.
Yes, only on the ground that the CD has not been produced despite several this thing.
Vehicle also.
We are allowing we are making the anticipated bail absolute.
Another allegation against him, my lord, in the player.
Against the driver.
FRC
driver,
Against the driver, not against him.
my lord.
Vehicle also granted.
Am I correct or did I read it wrong?
Yes, Lordship. Driver.
Driver was found to be
my lord.
engaging adolescent.
Adolescent, my lord.
It is not him. By the your name?
B. Islam, Lordship.
Mr. B. Islam Learned Counsel for the petitioner submits that the petitioner had been granted the privilege of an interim pre-arrest bail by the order dated 24/4/2026. The Learned Counsel submits that the case diary had thereafter been called for on several occasions. However, the same was not produced before this court. Full stop. The Learned APP has sought for another accommodation to produce the case diary. Full stop. The allegations against the petitioner is that the vehicle that he owned had been taken on hire and had carried more than the number of cattle which was permitted to be carried in such a vehicle. Full stop. The permitted number of cattle in the aforesaid vehicle could have been up to 16, whereas the vehicle was found to be carrying 21 live cattle. Full stop.
Overloading, Lordship, that is.
In view of these circumstances pointed out before this court, and in the absence of, and due to the, no, don't say in the absence of, and since the case diary has not been produced before this court, despite nearly 4 months having been passed from the date of grant of a pre-arrest interim protection to the petitioner, this court does not find it fit to keep the present petition pending and closes the same by making the interim protection granted to the petitioner absolute. Full stop. The court expresses its concern on the non-production of the case diary after an accused had been allowed a interim protection. The matter be brought to the notice of the concerned SP of the district.
Right, please, Your Lordship. So in this case, my lord, the petitioner seeking bail in connection with Kajalgaon PS case number 40/26, and subsequently, in this case, charge sheet was submitted, my lord. And now it registered as a special POCSO case number 27/26. And the TCR was called for, my lord, which is not received, my lord.
Are you under interim protection?
No, my lord.
What is the allegation?
Allegation is that the, my lord, petitioner has committed
Section
rape.
4 of the POCSO Act,
4 POCSO.
not arrested till now. One case charge sheeted.
Charge sheeted.
How many cases?
My lord, there is 2 cases, counter cases, my lord. And the counter cases, my lord.
Page 10 is what? Your
Page 10 is
FIR.
the FIR, my lord.
Whose FIR?
For I am seeking bail, my lord.
You are who?
I am Fazor Ali, my lord.
Oh. Eloped with minor daughter. Fazor Ali. And where is the FIR that you had lodged?
My lord, then the only page 25, my lord. We have that portion, my lord. Page 25, my lord.
You are nowhere here, nowhere in this FIR at page 25.
Page 25 is the type copy of the relevant portion.
Where are you? How
It
does
is,
this FIR concern you?
It is lodged by the father of the petitioner, my lord. This FIR from our side is lodged by the father of the petitioner, whose son has committed suicide, and the petitioner is the elder brother of the deceased, my lord. This is the case. As the case of
The case diary, anything?
No, my lord, charge sheet submitted,
One
my lord.
case charge sheet submitted.
Both cases.
both case, my lord. Both case
Both case
submitted
submitted.
charge sheet, my lord.
One is available. Which one is available? Charge sheet in which one?
Charge sheet,
35/26, it is available, my lord. 40/26. No.
no.
His case relates to 35 or 40? Which one?
40.
He is an accused in
40.
40.
This is now a special POCSO case number 27/26.
Kajolgaon PS case number 40 is now?
Special POCSO case number 27/26.
That has not come.
Not come.
Awaiting receipt of the trial court records relating to special POCSO case number
27/26.
27/26,
Pending in
this
the court of District and Session Judge Srirang.
Srirampur, list this matter again on 10th of September. 10th of September. CD and respondent number 2.
My lord.
CD
not received, my lord.
My lord, for a short date, my lord.
Hmm?
Because if your lordship sees the FIR, my lord, nothing was there to attract this section 8 and 12 of POCSO Act, my lord.
Where is the translated copy or something?
Page 9, my lord. The allegation is that the daughter of the informant and her friend, I have asked them to come into my house. Rather, it was the original fact is that my lord, they have trespassed into my fruit garden, my lord.
Eh?
Nowadays,
It's
my
like you offer small biscuits to cat or kitten and then ask them to come to the house.
reverse story is there, my lord.
Huh?
The reverse story is page 3, my lord.
Page
3, my lord.
3. Anyway, when?
My lord.
CDN
I have taken
service
steps, my
report?
lord. Please, let's keep going.
Right.
Lord, may upon an ambiguous question.
Yes. CDN this thing.
Service.
Huh?
Service.
Service report when? 27 or 2nd of September?
Second, man.
2nd of September.
Second, obligement.
Service report ahile korbo. List on the 2nd of September along with service report and allowing the PP to bring the CD. 40.
May I
Yes.
please, my lord, this is pre-arrest bail application, my lord. I am being a mental patient, my lord. I am the biological mother of the deceased, my lord. I am suffering from postpartum psychosis. Kindly for a moment, page number 4, para 7, my lord. that the petitioner begs to state that the accused petitioner is a mental patient, i.e. post-mortem psychosis patient, a severe, rapidly developing mental health emergency that affects a person's sense of reality after childbirth. The deceased was, the petitioner gave birth the deceased on 15/7/2026, died on 19/7/2026. My lord, still I am admitted at GMCH and treatment is going on, my lord. My lord, mother is the nearest and dearest one in this world, my lord. A person having a common sense could not do such type of act until and unless he is suffering from illness.
Who has signed the affidavit?
My lord, after preparing affidavit, we went there to took her signature, my lord, and we have taken her
In the hospital,
my lord.
in
At
front of the
GMCH.
in front of the notary.
My lord.
The notary went with you.
No, my lord, I told the fact to the notary, my lord.
Huh?
I told the fact to the notary that I personally went to the signatures at GMC's.
Yes, what do you say?
My lord, here we have received a case diary, my lord. PML report is not here, my lord. And from the inquest report, my lord, body is covered with blood clots, bruises seen all over the body. It was, my lord, lordship may kindly praise the FIR, my lord.
That is admitted.
BGD Hanihusi Ottawa 5 days, my lord, child, my lord, and thereafter strangulation the my lord, the child, my lord. It was
So, my lord, a sound person could not do this, my lord.
complainant statement, my lord, he has seen, my lord.
Just a minute.
5 days baby, my lord.
Complainant left them. How can he say?
Huh?
Complainant left them, my lord. The informant left them. Both his wife and his child, my lord. She was taking shelter at her parents' home, my lord.
Several witnesses are there, my lord. Yeah.
Even then, my lord, a sound-minded person could not.
Postpartum psychosis.
Psychosis, my lord.
From 11/8.
Mild.
When this is anticipatory.
This is clear, William.
What is exactly postpartum psychosis?
My lord,
the child is gone.
My lord, child is
the
gone.
proof is there.
My lord.
She is undergoing treatment for psychosis.
My lord.
Will you have the courage to take her in custody?
Postpartum psychosis.
Or taking into custody, then return back to GMCH? Better someone stands as a bailer to have her appear as and when necessary. Or it would be your responsibility to have a psychotic patient.
That is true.
Huh? Now we'll have to look at all sides. I'm not on the gravity of the crime.
My lord.
5-day-old child, mother killing the child.
My lord.
There has been some other, the father or some, that's a different issue.
Severe psychosis.
Somebody else's child, I will kill, whatever. There may be reasons. Mother killing the child and then you wanting to keep her in custody, will it help? Or will it be a burden? Heard Mr. A. Paramanik, Learned Counsel for the petition, also heard Mr. B. Sharma, Learned Additional Public Prosecutor appearing for the state of Assam. You take from this order dated 11/8/2026, the details are there, okay? The allegations in the FIR that the accused had caused the death of her 5-day-old daughter, had intentionally caused the death of the 5-year-old daughter. The medical documents annexed to the bail petition reveal that the petitioner is suffering from postpartum psychosis, which is stated to be a mental illness, full stop. The learned APP has submitted that the CD reveals that the child had been brutally put to death, full stop. The learned counsel for the petitioner has submitted that the petitioner being a patient of mental illness, she is required to undergo treatment and is in fact yet admitted in the Gauhati Medical College and Hospital in the psychiatric department.
My lord.
Stop. Having heard the learned counsel for the parties and also having considered the fact that the petitioner is suffering from mental illness and is admitted in a hospital, and it would be more of a burden on the state to take her into custody at this stage, I am of the considered opinion that the petitioner can be granted the privilege of a pre-arrest bail with appropriate surety of her attending the investigating process as and when she is required to do so. Accordingly, the petitioner, if arrested, shall be released on bail on furnishing a bond of ₹15,000 with 2 sureties of the like amount. You'll be able to take up 2 sureties. 2 sureties of the like amount to the satisfaction of the arresting authority. Full stop. The investigating officer shall be at liberty to verify the correctness of the mental illness and the admission of the petitioner in the hospital as stated by the counsel for the petitioner. And thereafter, if the same is found to be incorrect, bring it to the notice of this court on notice of this court and pray for cancellation of the present privilege being granted. AB accordingly disposed of. If it is false, we bring it to our notice. We'll do it in a day.
May I please?
Yes, sir.
Lordship, this is the second time bail application, Lordship. The earlier bail application was rejected on January 2026. After 7-8 months, the petitioner is before your Lordship. Lordship, the allegation is under section 21B. Recovery is 123,182 gram, Lordship. Lordship, the case is that, Lordship, there is FIR in para number, relevant portion is para number 13, Lordship. Where it stated that, Lordship, that at about 9:30 AM, the suspected vehicle was seen approaching, but by seeing the police party, they entered in a village road, and after went few kilometers, the vehicle stopped.
What new has happened, sir, in the meantime?
Yes, Lordship.
What new has happened in the meantime that I should consider it again?
Lordship, I'm waiting for a notice. I have not received any notice.
Eh?
I have not received any notice
For what?
to appear before the IO.
Yes, give him a notice today. On the next date, we will fix it. Bring a notice. Give it to him. We shut the case.
Lordship, the recovery made from the vehicle, I am neither the owner of the vehicle nor I was the occupant of the vehicle. The vehicle was lying somewhere else. The police says I was the occupant, but vehicle was taken to the police station, broken the lock and recovered 123 grams.
No, you locked the door and you ran away.
That is the allegation, Lordship.
Before the police came.
My humble
That is what-
submission, Lordship, I was not neither the occupant nor the owner of the vehicle. The NDPS, Lordship, that is nothing has recovered from my possession. I am not also the owner of the vehicle.
3 brothers. Manwar, Sanwar, Manwar and Anwar. Now Anwar is the owner.
No.
Who is
That Anwar is different Anwar. Father's name is different.
But
He has already been arrested.
yes,
One Anwar Hussain, one Anwar Kazi.
statement is there, my lord. Anwar, who is arrested, my lord. And
One Anwar is arrested.
Yes.
One
Two
Anwar is
arrested, Lordship. One Anwar Kazi and one Anwar Hussain. They have already arrested.
okay.
The Anwar Hussain is the owner of the vehicle.
Yes.
what is his father's name? Petitioner's father's name?
Petitioner father's name is
Kazi.
Jonab Kazi.
Yes. Resident of
Sanwar Kazi, Munwar Kazi, Anwar Kazi are the brother.
Village Palhazi.
They all brother.
Sathebari. Now, who is arrested? Anwar Hussain alias Kazi, 34 years, son of Junab Kazi. Village
Oh, he is
Palhazi.
both Kazi and Hussein, both same person.
No, Lordship. The third number is Anwar Kazi and fourth number is Anwar Hussain, son of
Mr.
Aibadi. It's
Counsel.
different.
Mr. Counsel, you would allow us to interact with the PP for some time?
Lordship, sorry.
Yes.
Sorry.
Take down his points. Then cut,
Sorry.
then intervene. Yes.
Three brothers. Now, one is this Anwar is arrested, Malad. Who is the owner of that car? Where it was seized? He, and this is intermediate quantity. He is arrested in another case, which is not Gauhati PS case number 0926, that is 21C,
Okay.
commercial quantity. Subsequently, when he was arrested in that case, Malad, it shown arrest in this case, present case. Shown arrest in the present case. And as per his statement, Malad, statement, Malad, all the three brothers are there doing same thing. And there are no new grounds earlier rejected last 2 pages of the Malad petition.
No, one thing is there, we are also perturbed. Page 15.
Malad.
Anwar Hussain and Anwar Kazi are two different persons with two different fathers.
But I am saying, Malad, Anwar Hussain, son of Junab Kazi.
Anwar Kazi is the son of Junab Kazi. Anwar Hussain is the son of Ayab Ali.
Yes. But statement, Malad, who give the statement, Malad? Anwar Hussain alias Kazi, son of Junab Kazi, Kazipara, Palhazi.
That is fine. What we are saying is your forwarding report.
Yes.
What is this? The FIR, it says that they are two different persons with two different fathers. That is what we are trying.
Yes, but now statement of the, because father's name is same. Statement
Yes, sir, we find nothing in this case to reconsider.
and they are doing this type of business. Malad, he is arrested, Malad, in a commercial case.
Nothing new, sir.
Present to petitioner, Lordship. Neither the occupant nor the owner, Lordship. And earlier order, Lordship, it was rejected on that at this stage. Now it is after 7 months, Lordship.
The 7 months,
We
they are
still not
very
receive
clear.
any notice. Police is after us. So at least interim,
Notice.
kindly.
Satisfy them, paste a notice, give them a notice.
It has already elapsed 7 months.
Only
Your name, sir?
Another thing, Malad, there are
We are not inclined, huh?
only BNSX, another thing, especially like NDPS case, Malad, where notice is recorded. There, Malad, evading arrest.
You are Mr. Islam, sir?
Yes, sir.
We do not find any circumstances.
So we are ready to appear, Lordship, to cooperate with the investigation.
No,
Heard Mr. S.I. Islam, learned counsel for the petitioner.
New
Also
ground
heard
is-
Mr. K.K.
Father
Parasar,
is arrested.
learned
That is the
public
new-
prosecutor, full stop. The learned public prosecutor has submitted that the case diary has been received. Full stop. The petitioner said earlier approached this court by AB number 2861 of 2025. And their prayer had been rejected by the order dated 21/1/2026. Noting the fact that there were incriminating materials against the petitioner during the investigation. Full stop. This court notices that there has been no recent developments which may require this court to reconsider its decision. Full stop. Accordingly, this anticipatory bail petition is rejected at this stage.
Fine.
Yes, sir.
Instruction regarding submission of charge sheet, my lord.
Yes.
That's it, Amit.
Huh?
That's it, Amit.
Yes, sir. What will you?
Yes, number
Yes, I will approve.
Heard Mr.
521
Smita, learned counsel appearing for the petitioner.
Number 1.
521 of 26.
Also heard Mr.
Dated 28 seconds.
K.K. Parasar, learned APP, who submits that the investigation has culminated in charge sheet number
521 of 2026, dated 28/7/26.
Learned counsel submits that the petitioner would approach the appropriate forum
Trial court.
The learned trial court praying for appropriate relief. Stop accordingly. This anticipated bail petition is closed,
Right.
granting the liberty prayed for. Yes. Service of notice is not there, na?
Jihan Kumar Lordship,
Service of notice completed, no?
So, Lordship,
Respondent number
I'm on the
two.
ground 47, 48 and
Yes. Service of notice on respondent number 2. It is at Gorchuk.
Lordship, yes, we have not yet received any instruction.
Okay.
Lordship will engage an amicus curiae, Lordship. Lordship may engage amicus curiae.
Well, amicus curiae, it was listed for the first time in motion for on 6/8.
We'll have to wait. If we want, if we find anything, we'll have to wait. Yes. Bihan Kumar, what does it say?
can you come to the last paragraph of it? That is,
No, not in this case.
it is.
Bihan Kumar, what does it say? I'm asking.
Jihan Kumar Lordship, that's the last paragraph also. The purpose, para 3 Lordship, the NK Honorable NK Singh judgment. Decision. The purpose of inserting section 50A, that is to now 48 of the CRPC, making it obligatory on the person making arrest to inform about the arrest to the friends, relatives, or persons nominated by the arrested person is to ensure that they would able to take immediate and prompt actions to secure the release of the arrested person as permissible under the law.
Now we just hold here for a moment. The informant is told that I have arrested, please go and engage a counsel. Does it seem correct to you that the correct person will be, the correct steps will be taken?
No.
Just for the time being, we come out of the black coats and the white bands.
To that extent, not.
And we try to understand whether an informant, who is the wife, who alleges that my daughter, who is the stepdaughter of that man, has been assaulted. Now the police say, please take this notice, go do what you can for him. Is the last paragraph satisfied in such a circumstances? In a circumstance where the son of the arrested, father of the arrested, brother of the arrested, who is really interested to protect his interest, is given a written notice. We understand that yes, he would do the best. In this particular case, we are only on this particular case. In these given circumstances, can a reasonable man say that the informant will do the best for the accused?
Lordship, why I was submitting on that, but that at that time, Lordship, that this year will be required. Why?
For what?
For that is Lordship.
An
Why,
advocate may have been engaged, suggested, and engaged.
Because that letter
By
part,
whom?
letter part, Lordship, you can. The arrested person, because of his detention, may not have immediate and easy access to the legal process for securing his release, which would otherwise be available to the friends, relatives, and such nominated persons by way of engaging lawyers, briefing them to secure release of the detained person on bail at the earliest. Therefore, the purpose of communicating the grounds of arrest to the detainee and in addition to his relatives as mentioned above is not merely a formality but to enable the detained person to know the reasons for his arrest, but also to provide the necessary opportunity to him through his relatives, friends, or related person
opportunity to him through his
relatives, friends, or nominated
now
person.
this 48 notice is given to the
Then we do not know also
to the informant matter ends.
if the arrested person has stated Lordship that I do not have any person give her notice who have maybe
is it are we not
no Lordship, but letter part Lordship. Why
there is a rubber band which can be stretched, and there is what we call a breaking point where the rubber band will break. If you stretch it and it breaks in your hand will be injured. It doesn't go anywhere else, sir.
Later part, Lordship, why I am submitting, Lordship, that part, Lordship.
Have you-
Retains related nominated persons to secure his release at the earliest possible opportunity for exercising the fundamental right to liberty and life as granted under Article 21 of the Constitution. That if that person is being informed, one of your relatives is being informed, so that he can ensure your release immediately for exercising the Article 21. Then in that case, Lordship, if the purpose of that, why it is this paragraph has come, Lordship, because of Article 21. If the purpose of Article 21 is being complied with by any way, if he is being, Lordship, why, when it will not be when it will not come into effect? Because Lordship, if that person is being not represented by any other person, I do not know in this case what happened, Lordship. But Lordship, if that person is not represented by any other person, then Lordship, that may be a ground, Lordship, that if because I do not know, that is my relatives do not know, that is why my right has been violated. But if that right, if his right is being not violated, and he is represented on the same day by he may also call any advocate also, maybe. But the purpose is being completed, is being fulfilled. Then Lordship,
We will answer that question in an appropriate situation by negating your submission that if a person is able to engage an advocate only on the basis of the section 47 notice, and there is non-compliance of any notice of being served upon a friend, family or relative who keeps in mind his goodwill, in that case, still there is a violation of the law laid down by the Supreme Court that the friend, family or relative who may be able to help him is required to be informed in writing in a language which they understand. For the present case, prima facie view is when the informant is being handed over the section 48 notice,
it's
allowing-
surprising, Lordship, because Lordship, informant normally it doesn't, Lordship. Why?
it has happened in this case.
It is very surprising, Lordship.
Not only that, she has been made a witness to his arrest.
Why it is, Lordship, that
And on top of that, his signature is in Assamese. And
Lordship.
the notice is in English without a noting saying that it has been in a language that he understands. He has been given the notice.
There in the city, Lordship. In I not it is there, Lordship.
Even if it comes or doesn't come, but the
In 47 also, it is
48 and the arrest memo, we are of the prima facie view that detention is illegal. Therefore, we will fix it on Monday, since it is Gorchuk. Have your service report on the service of notice on the respondent number 2, and keeping in view his constitutional right to freedom, right to liberty. We may appoint amicus on that day itself, allowing him to serve a copy. We'll take it up on Tuesday.
Till then, Lordship, scan copy may be called for, Lordship, because
By Monday.
Lordship, it will come, Lordship, because from Gauhati itself, Lordship.
That may be observed if does not come, Lordship.
Nothing will be observed. Whatever observation is here.
Lordship.
Yes. Heard the learned counsel for the petitioner, full stop. You are Mr. I. Islam.
J.S. Ahmed.
Heard Mr.
J.S. Ahmed.
J.S. Ahmed. J.S. Ahmed. Learned counsel appearing for the petitioner, the learned counsel for the petitioner has submitted that the notice under section 47 of the BNSS has been served upon the petitioner in a language that he did not understand, the notice under section 48 of the BNSS has been served upon his the wife of the petitioner, who is the informant in the FIR, and the arrest memo has also, and the arrest of the petitioner has also been witnessed by the aforesaid informant in the FIR. Full stop. The learned counsel has submitted that when the informant has raised allegations of sexual assault against the petitioner with regard to their minor daughter, the notices being served upon the informant and her witnessing the arrest would not suffice the requirements of law, and therefore the arrest and further detention of the petitioner would be rendered illegal. Full stop. The learned APP has submitted that in the event the petitioner had been adequately represented during the remand proceedings, comma, it cannot be said that the requirements of law had not been fulfilled, and therefore the bail petition would require a rejection, full stop. It is seen that the respondent number 2, no, it is seen that there is no report of service of notice on the respondent number 2. Accordingly, list this matter again on 24th of August 2026, by which time the learned APP shall have the service report on the respondent number 2 regarding the pendency of this bail petition, full stop. The also call for the TCR with regard to case number. Kindly give us the case number.
Session
Special case number 152 of 2025 from the court of the Special Judge Pokso Kamrup. Full stop.
Or admission.
এটা কি হয়, এটা হিয়ারিং অর্ডার আছে না? হিয়ারিং অর্ডার এটা করিলাম। We'll take up the hearing and that order if anybody wants to do it. We'll see. This is an admission matter.
Yes.
It is about the pay parity. Sorry, pay protection.
Pay protection.
Pay protection. That will not take much time. I think on the last occasion, in the absence of the standing, the CGSC, we had to. We'll take it up after these matters. Let us see.
For hearing.
Orders to কি হলো?
May I please, Lordship?
Huh? Yes? হবো or এটু কইলো?
My lord, we are challenging, my lord, discharging, during my lord, trial, we have preferred my lord, discharge petition. That was rejected by the my lord, trial court. Accordingly, we impugned under this my lord, revision petition, Lordship. That Lordship may find page my lord, 68, my lord. Page 68 is the my lord,
AP ready? Criminal petition? Huh?
Well, record not yet done from a.
What record?
Hearing.
Why is it fixed in hearing then? If records are not here, why is it fixed?
The records are there, Lordship. They have not gone through.
Or you have not gone through the records? Maybe after we hear for some time, you would get a guess. Yes.
My lord.
68.
68 page number, my lord, annexer 9. Annexer 9 is only impugned order. May I read, my lord? There are two accused.
Where is the FIR? Let us go by the FIR.
Lord.
We'll give you some time, Mr. PP. Just
No,
clear these things and then we'll take it up on a day where we can dispose it of.
Lord.
This is of 20?
28 onwards, my lord.
FIR is of 25.
28.
28.
Yes, man. Type copy, my
Now
lord.
what does it say? My son. Came to Gauhati from Kharbe to the.
May I read, my lord? I have the honor to inform you that my son Sohanur Rahman, 24 years of age, Kharubitia Dorong, came to Gauhati on 3 days break from Kharubitia. Today I got a phone call from one of his friend Arju. Arju, Lordship, before your Lordship, petitioner, regarding the incident that my son got injured and hospitalized at downtown hospital, Dispur. After visiting him at hospital, I have suspicion that somebody might attack him with sharp weapon with the intention to murder my son. He is right now struggling with his life in the ICU. The incident was occurred on today at around 11 a.m. at Anandanagar 6 mile. This is the valid FIR. This was investigated, charge sheeted. Matter is now under trial. At the time of consideration of charges, Lordship, we have preferred in petition. After perusal the record, we have preferred in petition for with prayer of discharging. That was rejected. So we basically we relying upon Lordship one statement that is
Tell us where we exercise the revision petition,
my lord.
where we exercise our that authority. Just tell us that. What is wrong? Just tell us that.
After perusal of record, we found that prima facie materials not appeared against the petitioner before your lord. And on the dead ground, we preferred this petition, lordship. Why we prefer lordship that page 75 is there, my lord. Kindly have a look, man. Page 75, lordship. This is the 161 statement. This boy and petitioner, they both went to the place of occurrence with a view to extend helping hand, and now he is under the trial. So kindly have a look, lordship. Page 75. Along with Arijit, he is one Ashik Akram Faruqi. Along with Arijit, I have been living in rented house since so and so. I came to Gauhati for the purpose of MIT coaching. I have passed BCom. Alisha is nickname of Nasima Begum. We called her Alisha. On 30/11/2020, I meet Alisha at the room of Arijit. At about 10 p.m., I leave her to her rented house of Anandanagar 6 mile. Arijit and Alisha had drinks at their room. Arijit asked my son R15 bike. I gave the key. After some time, they came and she said that he cannot go as he vomiting. She asked me leave her. I gave leave her. Thus came to know her. Arijit stays at first room of the flat. Nikhil Soikia stays at second room of the flat, and I am staying at the last room. Earlier at the last room, Sohanur was there. Sohanur is a deceased boy here. Now Sohanur at Kharubitia. I read in class 5-6 with Sohanur at Hujai. Through Facebook, came to contact with him. Last year, exchanged mobile number with him in a marriage ceremony. Then shared my views of coming to Gauhati.
Same day I decided to come to page 76. I received a phone call.
Yes.
Over phone, she told Sahanur himself put knife. Bleeding occurred. You come. I did awake Arijit from sleeping and informed him the matter. Phone was online. While I informed, asked me to go alone, not with Arijit. I said I will not go alone. So what happened?
Yes, well. Phone was online. While I informed the matter.
I don't find anything.
Lordship.
You are Arijit.
Yes, well.
So Arijit did not go. You are saying that you did not go.
Now, Arijit was also there, my lord. Arijit and this boy, the PW 71, both went to the place of occurrence with extend to with a view to extend helping hand. Now he is under trial, lordship. And we are trying to project our case that, my lord.
It's a matter of trial.
Under trial, lordship.
It is a matter of trial.
It is a matter of trial. And my lord, he's already examined, my lord, during trial. This boy also examined. This boy also examined. After perusal, this, my lord.
Whoever, if the trial is going on, is the trial proof that you were not there on that day, or that you were only there to help? Matter ends.
This boy is starting like that. So, my lord, this boy, this witness is starting
like that where? Before the police, before the trial court where?
Before trial court also he said like that.
So,
lordship. After perusal, this is matter of abuse of process of law, lordship. No way he is connected with the incident, my lord. no phone call, no, there is no any planning, just under suspicion, he may be there. Both were went to the place of occurrence, Lordship. This boy and petitioner.
Anybody who has not seen the murder
My lord.
and is suspected of
Yes, my lord.
with some proof against him may have to face trial.
But it abuse of process of law, Lordship.
By whom? By the state?
No, my lord,
To
prosecution.
what end?
No, he is not named, my lord, just suspicion that he might be.
It cannot be named. How would the father know who put a dagger in his son?
Yes, my lord.
The father would never know. He would only say that it's a case of murder by his friends.
My lord,
He did not
prosecution
know.
bring him under the trial, but
Tuesday or when? We'll have it on 8th of September.
I'll go.
Kindly be prepared.
On 8th, my lord, trial is fixed. Can it be before, Lordship?
Next week is full. September 3rd and 2nd are full. 31st of August we can try.
Lodge.
31st of August for learned PP to make his submissions. We are not convinced. Show us something more. Otherwise, we are not convinced.
Well.
Order. Yes, sir.
Well, basically, this review petition
Ah,
for modification of slight in the direction part, my
tell us.
lord, the retail outlet, it is a B side retail outlet. There are two categories. One is A side and another was B side. So for A side, my lord, retail outlets are concerned, it is operated by the company itself. The lease is executed between the my lord lessee and the company. And this is a B side. The lease was executed between the dealer and the petitioner. Petitioner is the landlord. And there is a direction from this court that land is required to be handed over by the IOCL to the petitioner. That cannot be because, my lord, land is in possession.
Very well. Have you vacated it?
My lord.
Has the IOCL vacated it?
My lord, service has been stopped, but.
Have you vacated it?
Yes, I could not because, my lord, the interference of the, my lord, the possessor, the dealer, they told that we are filed a writ appeal against the order.
Pending of a writ appeal is unless there is a stay.
That's true, but forcefully we cannot. It is our property. We are trying to, my lord, take back our machineries.
You are not aggrieved by this order.
No.
You would like to leave the property?
Yes.
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 But
so far the handing over of the possession of
that part,
only that part, my lord. Review is for that part only.
In that case, Lordship may modify that part. At the present moment, my lord, the platform is not functioning, but there's still the equipments are lying there in my land. We have also filed a contempt regarding to this order, because they have not cleared the land.
Lordship may kindly.
Have you received notice of any writ appeal against this?
Writ appeal, there's a delay, my lord, and
you have received notice and there is no stay.
There is no stay. Well, and what happened? After that, the private respondent have all went to the civil court for injunction. There, the injunction was not granted. Again, they have approached the High Court by filing your first appeal against order. There, by suppressing some facts, the status quo has been given as of
Status quo regarding the land.
Land, my lord.
Possession of the land.
My lord.
Not to the IOCL.
Not to the IOCL.
Not to remove the machines.
No way related with the land.
See, if I remember correctly, we had found that the IOCL was more adamant in not leaving the land rather than the other parties. That was the view, I think.
No.
If we remember correctly.
The Lordship may kindly see the prayer person, which is quoted by your Lordship in your judgment as 84.
Page 80?
Page 84. There was no prayer as such, and there was no allegation against the IOCL regarding the land.
At least let them clear the
Ah.
equipments, my lord.
Shall not be issued directing the respondents to immediately stop the operation.
But, my lord, that operation has been stopped, my lord.
To remove all fuel vending and
That
pumping.
I could not because of the, my lord, adamant attitude of the, my lord, possessor. We are trying to remove our machineries from the,
Indian Oil Corporation is so weak.
my lord, they said, my lord, there is a writ appeal, that is why.
There is no statement. Appeal is not yet been admitted, my lord. There's a delay. We have filed
No, all we can do is we can, if you agree to it,
Lord.
we can say that the handing over of and peaceful vacant possession of the land by the IOCL. Since the IOCL was, no, how do you say that the possession of the land is with the respondent number?
5.
5.
He's not been made a party here.
Is he not a party here?
Not in the review petition, my lord.
The writ petition,
Then how can I? Then how can I say it is in the possession of whom?
my lord, they were not represented in the writ petition also, my lord.
Maybe, but
They were a party, my lord.
they were parties, but
They have filed the appeal. They have filed now filed
They've-
an appeal.
therefore therefore notice has to go to them. If we are to say that respondent number IOCL is not required to hand over peaceful and vacant possession,
Yes.
to give him complete relief, we must direct someone to give the vacant possession. Vacant and peaceful possession.
Or
If
lordship,
there is no other impediment in law, which will include the status quo order, yes.
My
or
lord.
lordship and direct the authority to at least remove the machine, my lord. That part.
No, that I
is
cannot do in a
already-
review. That you have to come up in a contempt and say that they are not
contempt is
removing it
pending,
as.
that is pending,
Ah,
that is
that
pending.
that will
That
take
notice, we are not
For
agreed
this,
with.
unless you make respondent number 5, 6, and 7 possibly of the writ petition as parties, can we consider this review?
And suppose, my lord, the appeal is admitted, there may be also different order, my lord. If the appeal is admitted,
I don't know.
that also. Or we may file an objection to the review.
Kindly have paragraph 4, sir. Paragraph 4 of your review petition.
Right.
I am unable to understand that part.
My lord, there is a typographical error, my lord.
The Honorable Court reject the judgment
My
which
lord.
has been.
My
What
lord, there is-
judgment did I reject?
Reserve is, my lord, typed as reject.
Reserve is typed as reject.
Wrongly typed as reject, my lord. I'm extremely sorry for that, my lord.
No, I was not able to understand what did we reject.
My lord.
No offense taken, but
Yes,
how was it?
typographical error, my lord. Reserve was typed as reject, my lord.
I'll give him the opportunity to file an objection, if any. And in the meantime, you look into whether the other respondents in the writ petition are required to be made party here. If
Well,
we review it,
My lord,
then that opportunity has to be there before we allow the review.
my lord. And I may be allowed to incorporate the other respondents in the review petition.
That is what
But-
we'll give him the option to file an objection.
My lord, simultaneously, your lordship may.
2 weeks time we'll give him. In the meantime, you
the
file
meantime-
your implement petition.
My-
You don't need an opportunity, you don't need a liberty for that. It will be before this court, so
my lord.
we'll remember it. We'll allow it, we'll allow the amended memo of parties. Heard Mr. D.K. Sharma, learned advocate, learned counsel appearing for the petitioners. Also heard Mr. M. Smith, learned counsel, appearing for the caveator. Full stop. This review petition has been filed by the applicants seeking a review of the direction given at paragraph 19 of the order dated 11/11/2025 in WPC number 4499 of 2020, whereby the applicants were required to hand over peaceful and vacant possession of the land to the petitioner, to the writ petitioner, within a particular period of time, full stop. Within a particular period of time, comma, by removing all fuel vending and pumping paraphernalia which were present on the aforesaid land. The learned counsel for the petitioner has submitted that the land in issue is in the possession of the respondent number 5, 6, and 7, or is it only respondent 5?
5.
Respondent number 5, 5 and 6 of the writ petition, and therefore it may not be possible for the present petitioner, comma, the IOCL to hand over vacant and peaceful possession of the land to the petitioner as directed, full stop. Learned and Mr. M. Smith, learned counsel for the aviator, has sought for an adjournment to raise his objections to the present petition. Full stop. Request allowed. List this matter again on 18th of September 2026. Stop.
If possible, my lord, early date may,
11th?
if this honorable court may.
11th? 11th of September 2026. Stop.
Some item 11.
The last item again? Criminal, civil. Yes, sir.
Your lordship, if I may just brush my
Recapitulate.
knowledge. Yes, your lordship, just want to recapitulate the facts. Yeah, basically the petitioner herein is seeking protection of pay. Now, the genesis of this particular claim arises from one OM of 1989, wherein the objective of the OM was set out in that OM itself as to why protection should be granted, so as to attract talent. Now, in that particular OM, no such criteria as such as to the means of selection was mentioned.
Whether it is by interview or whether it is by written test.
Yes, whether it is by combination of both written test and an interview.
Or simple interview.
Now, in 1998, this was going on. Till 1998, they came out with this OM where they restricted the scope of that 1989 OM by saying that only those recruitees who are selected on the basis of interview only would be given the benefit of this pay protection. Now, this particular 98 OM was put to challenge in many cases before the Honorable CAT in various benches of CAT as well as the Delhi High Court. And the authority in this particular case was the Delhi High Court judgment of Sanjog Kapoor. Now, on the basis of the Sanjog Kapoor judgment, many cases actually were filed and costs were also imposed upon the departments because every now and then, even after Sanjog Kapoor, they came up with this same plea that no, this is only based on this OM says we are restricting it only to the interviews only. Because the two questions which arose before Sanjog Kapoor was one, whether it is permissible for the DOPT to issue a clarificatory OM which would reduce the scope of a prior OM without any reason. And secondly, was whether the distinction between selection on the basis of interview and selection on the basis of open competition is based on some reasonable intelligence here, or whether it is supported by any reasons. Then, if not, then it is arbitrary.
the department in all the cases in before Delhi High Court as well as that, they could not give forth any kind of, the latest being, I'll produce the latest judgment also, this February 2026, wherein the Honorable Delhi High Court said that no reasons are forthcoming. Then only issue, because now they came forward with this OM of 2020, wherein they said in the OM itself, because of various judgments which are actually passed down on the bridge, now we are issuing this particular OM wherein no such distinction exists as to selection on the basis of interview or selection on the basis of interview plus written. So now what I'm praying for on the basis of the law laid down by the Sanjay Kapoor judgment and followed by various high courts as well as cat benches all over India. So I am entitled to this pay protection. Also, one more important fact, which was actually missed on Sanjay Kapoor, is FR22B. Now, FR22B says, even if I join a particular post, and I submit a technical resignation, which had actually happened here, wherein resignation is merely a technical formality because I join a different department. Then also, I am entitled to pay protection. That is the language of FR22B. And to that effect, the DOPT had come out in after just 5 days after this particular OM. They came out with this OM of 5/8, just prior to this OM, 5/8/2020, wherein they cited this example as to if suppose somebody is working in any PSC or autonomous body or any government department who follows this scale, this pay scale pattern, instead of the industrial DA, that one, not that one. But those who follow this scale of pay as per the 6 CPC as well as the 7 CPC, now it is 7 CPC for time being, they have to give the benefit of FR22B. Now, FR22B is very clear on this aspect, and that is, I have an annex also for your lordship's consideration, wherein the language is very clear. After I join the new post, I undergo a basic probation period, and I should be granted during the probation period itself. If I am granted a higher substantive pay in my earlier post, then I should get the pay of the substantive pay of the post which I was holding earlier to this particular post.
If you are holding a higher post,
If you
are doing a pay of a pay higher than the one where you have now joined,
yes, then I'm
minimum of the one that you have not joined, they would adjust your pay to fit in with
that
your
particular
pay
which I was drawing in the earlier organization. So that is what pay protection envisages in this OM of 1989 also. And one more aspect which was actually brought forth after Sanjay Kapoor, Nagendra Kumar Jha came, wherein Nagendra Kumar Jha
was it Delhi High Court?
Delhi High Court. There also, the Honorable Delhi High Court observed that this 98 OM is a clarificatory OM, and 1989 OM is the original one, which was issued in the name of the President of India. 1998 OM is not issued in the name of the President of India.
By authority lower than him.
By just the Secretary.
By an authority lower than him.
Yes. But it was so, Honorable Delhi High Court held that a clarificatory OM can only clarify or expand the scope, but it cannot reduce the scope, and that too, it cannot actually override a OM which was issued in the name of the President of India. So I base my submissions on those bases on.
Okay.
Now, coming to the case in hand, Your Lordship. Now, I was actually working in the NTPC. Now, when I completed my probation period on 19/9/2012, the advertisement for Indian Engineering Services came forward, which was dated 10/3/2012. Now, in terms of that particular advertisement, I appeared in the selection process and ultimately I was selected, and I was appointed to, the appointment letter was issued on 17/8/2015, and I joined BRO on 26/9/2015. Now, when I, in that particular, before joining, I was supposed to submit my last pay certificate. And that is very important. If Your Lordship peruses through page number 51, annexure 8 of the writ petition, therein, my pay scale is mentioned.
Last pay scale 24,900.
24,900 to 50,500.
28,040 DA 25. Huh.
Basic is 28,040. Now, when I joined BRO, which is after joining BRO, my pay scale, Your Lordship, a DO Part 2 order at page number 52, annexure 9.
52.
Yes, Your Lordship. Oh, this is, I'm sorry, this is an NTPC base scale.
This is some Amit Yadav.
Amit Yadav, this is the petitioner.
Oh, yes, yes.
In fact, Your Lordship will find it in my representation.
Basic 28040.
Basic pay is 28. Your Lordship, if I may take Your Lordship to page number 54, there in the representation, everything is clear itself.
This is what? This is by whom?
This is the NTPC last pay certificate,
52.
51 and 52,
NTPC.
NTPC.
Huh.
And therein, I actually, after joining, I submitted after completion of my probation period to a representation on 18 December 2018. I submitted a representation for fixation of pay, page number 54 in the representation at paragraph number 12 and 13. I have mentioned as to what I was getting in NTPC and what I'm getting now in GRIF, which is basic pay is 15,600 rupees. So I am already losing out 13,000 rupees. And I'm getting much lower, which I should have actually got. Now, of course, that gap has actually widened after 7 CPCS come into 4. Now, after that, they had rejected my case by this impugn order, which is at page number 62, saying that one case of KK Sharma was taken in this case, saying that last paragraph, annexure 13, page 62, paragraph number 3.
Understood. They've said that it is not by open competition.
Not through open competitive examination, and hence has not agreed to the proposal. This was next page. This was actually intimated for all similar cases, disseminated to up to a formation level for all similar cases. This was taken as the rejection letter, and I was informed by this page at page 63 and 64 that this is the ground of rejection.
Okay.
So I approached the Honorable Court, this Honorable Court again. This Honorable Court directed them to pass a speaking order taking into consideration Sanjog Kapoor and all the judgments. But ultimately, which is at page number 70.
No, this is by Krishna Kumar.
Yes.
Then you have Vinayak.
I was also a petitioner in that particular case. There were 3 writ petitions. Krishna Kumar,
Amit
Vinayak.
Yadav. No,
Amit
there
Yadav.
were 3 writ petitioners in 3 different writ petitions.
3 different writ petitions.
This was given by Justice.
Justice Suman Sam. At
Yes,
para number 6, page 73, this Honorable Court directed them that take a decision, pass a speaking order based on the judgments. But ultimately, they passed the speaking order, which is at page number 77, annexure 19. No reason is forthcoming. Just rejected. Page 78, page 79, 77. If I may just read out last paragraph,
No, the ground of rejection is there.
No.
That the new OM is from 2020. Therefore, I will not give you.
I'm not on that particular. I never claimed that, Your Lordship. That came out during the pendency of the writ petition itself. I was never claimed that. That is not my prayer also. I claim simply on the ground of this 98 OM being illegal. Now everything is superseded. 98 OM also goes by the new OM. The new OM itself says at page number, the new OM is at page number 65.
Okay. Yes, sir. What do you say?
My friend has taken your lordship to my case also. 89, my lord, the first First, the OM is of 7/8/1989, which my friend is relying on. Then came 10/7/1998, clarification was made. The distinction was brought, but interview and written complete examination. Then that this 10/7/1998 was challenged in various honorable cats, and it went to the Delhi High Court. Division bench of Delhi High Court in 2007, Sanjay Kapoor came, my friend just pointed out. And then again, the Jha. And lastly, my friend just mentioned it, in 2026 February, the other case, that Subham Pandey's case came on the same point. But our stand consistently has been, 89 has been clarified in 97, 98, sorry.
98, huh?
Then comes 13/8/2020, where the mode of selection was done away with. But 13/8/2020 perhaps would not come into his case because he was appointed in 26/9/2015. 15. So on the day on which he was appointed, the OM, which would have held, because now 10/7/1998 OM has held to be arbitrary. But the Honorable Delhi High Court.
So in 15,
Yes.
it would still be arbitrary.
Yes.
So your stand taken thereafter would still be arbitrary.
So that is our, basically, that is our case. Now, since that division bench judgment of the Honorable Delhi High Court still remains.
This
Subham Pandey has come up in February.
Subham Pandey, do you have a copy of
Yes, yes, I have all the copies.
Sanjog Kapoor?
Sanjay Kapoor, 2007.
Yes.
In a particular case where Sanjog Kapoor was cited, the day I went to the judgment was a day when a similar matter came before me. And the client told me, what a Sanjog. That is how I remembered Sanjog Kapoor. I was reading the judgment and we were discussing. So it was a Sanjog.
Sanjog.
And I remembered Sanjog.
Just fate.
No, not Sanjog Kapoor, the Sanjog Kapoor, I know.
Last judgment is of Shubham Pandey, para 22 to 29.
And regarding his FR 22, we have replied to that in para 16, page 93 of our affidavit. But because that will not come in.
Why?
Because these notification of 5/8/2020 was given prospective effect from 1/6/2016.
No, we are saying, what he's saying is that FR 22 existed prior to 2020, sir.
Yes.
So whenever he comes in with a technical resignation,
yes,
with the knowledge of both the department which has let him go and the department which is taking him in, pay protection becomes a right under fundamental rules. So the coming in of the 2020 notification is neither here nor there. 2020 notification, we can all forget about it. We'll forget about it. Now, if you're in opposition, you have not replied to the FR 22 stand.
Yes.
You have replied that 2020 will not come in.
Yes.
The number itself is different. You are talking of 2020, he's talking of 2022. No, he's talking of only 22.
Only 20.
He's talking of a fundamental rule.
To B1, that has been replied. That's what I'm saying.
What does it say?
Let me read out.
Why will it not come in?
Page 79.
Huh?
In that OM itself, the FR 22 is quoted.
My affidavit.
No.
My running page would be 93 in my affidavit.
That is what I was asking.
Yes, 93 page.
Where have you talked about FR 22?
Yes, FR 22. Roshma kindly see, Madam. Para 16.
16.
Yes. Is it also got it, Madam?
Waiting for para 16.
Page 93, para 16.
No, page 93.
3.
Page 100. Page 93. Affidavit by Mr. Rajkumar.
Yes.
At page 84.
My lord.
Somehow in my petition, it has come up as page 89. The counter affidavit by the UPSC is prior to that. Therefore, your numbers have changed.
Sorry.
For me, it is page 100, yes.
Now, Lordship, kindly come to para 16, no?
With regard to the statement made in para 22 of the writ petition, the answering deponent begs to state that protection are paid to the central government servants consequent to the appointment to a new post in different service or cadre in central government through direct recruitment where either highest duties and responsibilities.
Here you have said that the reference of the 2020 office memorandum to FR 22 will not be applicable to his case. That is the basic thing that you have said. But you have not said why FR 22.
Yes.
In the absence of the notification of 2020,
Yes.
it will still not be applicable to his case.
Let me read out, madam. The line starting from in the seventh CPC scenario, wording is not applicable to the petitioner's case. As per para 6 of the Government of India, Ministry of Personal, Public Grievances and Pensions, Department of Personnel and Training Matters, so and so, dated 5th August 2020. As this order takes effect from 1/1/2016, this is what I was trying to point out.
No, the reference to FR 22
My lord.
in the notification dated 2020 will not be applicable to him because it has to take effect from 2016 onwards.
Yes, ma'am.
FR 22 ipso facto without the office memorandum of 2020. Tell us why that will not come to his aid. In 2020, they have said, okay, we will also apply FR 22. Forget this office memorandum. Were you not under an obligation to have applied FR 22 at the very beginning? That is his case.
Yes.
So we can close this.
My lord.
So your relief, what is your relief claim?
Your lordship, it's at page number, I should be granted the pay scale of 25,800 with effect from my date of joining, your lordship. Mandamus is required for fixing the pay of the petitioner at 28,040 plus grade pay of so and so, and
We are not setting aside OM dated 10/7/1998. We don't need to. We will say that the clarification which has come from the judgments would apply to that 1998 and therefore it exists, read in conjunction with the clarifications already adjudicated upon by the competent courts of law.
Yes.
Yes, we are not setting aside anything. Then where is your letter which you want set aside? 22/2/19, this is to be set aside.
The speaking order.
No, that was that was the subject matter of the earlier writ petition,
Yes.
so we cannot set it aside now. Because that writ petition had asked them to take a fresh decision, meaning thereby that it was already set aside.
Set aside.
Yes?
So that was, but this speaking order 4/9/2024.
This is the one we want to do. Impugn policy decision 6/3/19, where is it?
6/3/19 is the earlier writ petition wherein on page number.
Show us 6/3/2019, just show us that letter.
Yes, your lordship. Page number 62.
No.
62.
Page number 62 is 22/2, sir.
Yes, 22/2019, based on which they issued this 6/3/2019.
Where is 6/3/2019?
Page 63. 63.
That it will be applicable to all.
Yes.
We cannot set it aside because that is the decision based on 22/2/19, which
19.
was already a matter of challenge in the earlier round of writ petition.
Yes.
So even this will not be set aside.
Yes. If this September 24 goes, everything goes. Your lordship.
Then September 4/9/2024, after the fresh round, whatever order has been passed,
Yes.
that will be set aside, giving you which relief?
That in my prayer, your lordship, that my pay should be fixed at 28,000.
040 plus so
040.
and so. With
Effect
effect from 26/9/15 with that.
The day of my joining, your lordship.
We'll say that your pay would be fixed at so and so from the date of your joining, and you'd be entitled to all consequential benefits thereafter in accordance with law.
Yes.
We will not be sitting to calculate all of it.
Yes, yes. That they will, department.
And we'll give you the liberty to that while submitting a certified copy of this order, you would have a representation where you would give your calculation of the consequential benefits which might arise out of the order of this court, on which they would have their own calculation.
Yes, sir.
And whatever is due
Whatever.
is required to be cleared to. Will they do, sir?
The difference in amount, already,
Huh?
the difference in amount.
No, your pay scale has to be corrected first.
Yes. That
Last
has to
3
be-
years from the date of, oh, I should not be telling you the reliefs, should I?
Understand.
Those will for you to, those will
Yes.
be for you to put in your representation.
Yes, your lordship. About.
Okay. Tenth of September, delivery of orders. 10th of September, we'll have it for delivery of orders.
Highly obliged.
I'm keeping it for delivery or orders because we'll try to formulate the facts. Anything wrong in that, you'll have the opportunity to point out.
Yes.
The river heard both the parties. Arguments concluded. 10th of September, delivery of orders.
Highly obliged, lord.
Oh, yes, sir.
And Malan, I appear.
Your affidavit is the one I was referring to.
May I please, Your Lordship? It's a joint prayer, Lordship. Can it be on 3rd of September, Lordship?
Why didn't you take 31st of August? In the calendar, it was somewhere on the top of August. Therefore, I was going up to 28th of August and then I was jumping to 2nd and 3rd. I missed 31st of August totally. We have some time on 31st of August.
It's a Monday. It's a Monday.
2nd and 3rd are preceded by 2 holidays. Preceded and succeeded by 2 holidays. 1st and 4th are holidays.
Only concern is it is Monday, motion day.
No difficult. Motion day, what
Can
would
be
be?
disposed of by the 2018 meter. So any 3rd of September will be Thursday, madam.
Okay.
If it is convenient to the
3rd of September. At the request of the learned counsel for the parties, list the matter again on 3rd of September, on which date, it's on the hearing column, huh?
No, Lordship. Admissions.
at the administration stage itself.
On which day an attempt would be made to dispose the matter, since it relates to the year 2018.
So the
Campus proceeding are stated.
the interim may kindly be continued till the next.
The in the order past earlier continues.
Deeply obliged. May it please, Your Lordship. Okay, this is a small matter, Lordship.
Let's do it.
Your Lordship.
Should we do it?
Yes, it can be.
Bolo.
Yes, Lordship. The petitioner before Your Lordship has assailed or FIR, has challenged the FIR as well as the order by which the cognizance has been taken. May I take your Lordship to page number 15, the FIR, Lordship. Recent negligent.
Page number?
15, Lordship, of my petition, Lordship.
Page number 15.
15.
The translation is at 12.
Yes, translation.
Yes.
I shall read the translation part, Lordship, at page 12. More specifically, I beg to state that on 27/05/2019, about 9 AM, when I was going to Hottebari High Secondary School through the Polla Road from my residence by Marty so-and-so, a vehicle being against the so-and-so. When we reached the Samata powerhouse turning, all of a sudden a dog came in front of the car, and as such the driver of the vehicle lost his control and met with an accident as he was driving in a high speed and dashed the car into a tree. It is to mention that the accident took place due to recent.
Okay. And the driver, the owner of the car has implicated the driver. She's the owner of the car.
She is not the owner. She is the wife. She is the wife of the owner.
Whatever, the wife of the owner, she says that my driver drove it in a very rash and negligent manner. There was a dog and we hit the tree.
Actually, on that particular day, Lordship, there is a heavy rainfall. There is a Lordship, in the trial court record, Lordship will find a sketch map. There is a turning, and when the car was about to take turn, the dog came in front of the car. So accordingly, the petitioner had to apply his brake. So car got slipped and dashed in a tree. And thereafter, she got injured and she was admitted to hospital from Nalbari.
Thereafter, she was taken to Hill City Hospital, where she undergone some treatment. And Lordship, my response submission at present also, I am the employee under the informant only. As on date, I have worked under the husband of the informant for last 21 years. In fact, it will be last 20.
Is there any ill will between the informant and his wife? No.
No.
They are not fighting. Why don't you forgive? Forgive and forget. What is it called? An accident.
Yes.
What is an accident? Something done unwillingly
Yes.
is an accident.
Yes.
Yes, you really want to contest?
No.
And the PP, you want him punished for rash and negligent driving when he's still the employee? Huh?
If the informant has no any objection, madam, party.
Even if they had some objection,
Fine. But otherwise, madam, it was from the statement of the complaint, madam, informant, madam. It was on a negligent and rash and driving, madam.
were you arrested ever?
No, Lordship.
You were never arrested.
At the point of time, was in nationalism, when I appear before the concerned police station, Lordship, all the documents have been seized during the accident only, and thereafter the police has granted bail. After I approached the after search it, I approached the court. I prayed for a discharge, but search has been framed, and that was not allowed. Being agree, I approached the court.
There are circumstances which come to the mind, like Sanjog Kapoor came to my mind. Something must have come to the mind, said, no, you should face a trial. Yeah, rash and negligent.
And
Yes, what is the definition of a rashness or negligence?
38.
What is the definition of rashness or negligence? High speed may not be rash or negligent. High speed is high speed. There is no speed limit given there.
Limit not there.
When was the occurrence? 6 years ago.
And
Perhaps evidence.
Trial is stayed.
yes, trial is stayed.
Trial is stayed.
Yes, by this honorable court, trial is entered, trial proceeding has been stayed while issuing notice.
10/22.
Can we say that we do not find any wrong in the initiation of the trial process, but
Cognizance.
since both the taking cognizance, but since both the parties have agreed before the court, and there is little or no chance that there would be any conviction in the matter. The punishment being of 1 year, no, I think 6 months.
Yes, sir.
Or 1,000 rupee fine.
And
The continuance of the trial would rather give rise to bad blood between the parties when one is serving the other. And therefore, in exercise of our powers, we do not deem it fit that the lack of chances of conviction is what we would. We'll quash it.
Yes.
Disposed of. Proceedings or should we dictate the order here? We'll make corrections inside. I'm disposing it of its cost.
deeply blessed, sir.
Now you don't drive any speed, do you?
No, Lordship.
Now no speed.
Actually, Lordship, the husband of the informant is a doctor. At present, sometimes I used to take him to the hospital.
Now, even in case of emergency, don't drive.
No. That is the first time I met with an accident. Thereafter, no accident. And at present, just simply sometime I used to take him to the hospital, and otherwise, I used to sit in as a receptionist also.
May we please, my lordship. This is the revision petition against the order concurrent finding, learned trial court, as well as appellate court. Here the LCR has already been received.
LCR not received.
This is received, and this is regarding the dishonor of said.
So why don't you pay him and get rid of it? When there is a concurrent finding, you'll have to give us something very big.
But the
Do you have it?
situation is that the petitioner is a daily laborer. He is not in position to.
Why is he issuing checks?
But here the fact is that the the fee of the rest.
And to the tune of 8 lakhs.
It lacks here 4,70,000 SEC amount.
Check.
SEC amount.
Ah.
The plea of the petitioner is that he did not make any transaction with the respondent.
But he issued the checks.
But the plea is that he was issued to the another person who is the uncle of the
Whosoever the check bounced.
Yes.
That is the offense.
Yes. Here the learned record has already been observed that the presumption 118A and 139 has been established and
You issued a check
yes.
without having the money.
Learned trial court decided the
So why don't you come to a compromise, sir? You also know the condition of this man.
on the last
What do you say?
I'm a cancer patient since last 2 years.
Of course. We understand your requirement for money. But he is required to pay 4,70,000. What have you paid till now?
Nothing.
But till
Nothing.
Nothing has been paid. On the appellate court also there is no such order.
To deposit.
Yes. Yes, so on the last occasions, I made prayer before this honorable court to send it to the mediation. If the matter will be settled, discussion between the two parties.
No, it is said that there is a possibility of settlement and you would like to have some instructions. What is the
Yeah,
instruction?
instruction is that if the matter will be sent to the mediation, then the both side will come.
He must have made you some suggestion. This is what I can pay, this is what I cannot pay. Some suggestion?
Yes.
What is that?
If the check amount is, but the compensation amount is not possible.
What is the check amount?
Check amount, at first, they have to pay the check amount,
Ah.
4,70,000. Then they can say that,
But
I want to compromise.
Or no, all said and done, it is between you and the accused. Yes? You may even settle for only for the check amount and say that, okay, take a chalo mil gaya. Hai na?
My instruction.
If you
my lord-
press him for 8 lakhs, only we all will be, I will be carrying a file. You will be carrying an argument and he will be carrying a hope.
there is a plea is plea is that that person, the particular person, paid only 1 lakh was paid to that person.
You want to pay him the check amount or not?
Yes, I'll take instruction.
Not by a check. This time not by check, this time by FD. Sorry, DD, demand draft.
If it is come to the settlement, then
How much time? Tell us.
it's,
Tell us how much time. When do you want it listed? Give us a date, proper date.
2 weeks time may be given to take instruction. Because on the last occasion, he was not agree about it.
Because my
Let
lord, he is in bed.
See, the bedridden condition of your client cannot be attributed to him. We cannot go that far. His money, he's paying some money may help you, but your condition is not because of him.
No.
So let us not be on that. Let us take what is actually due. The law can give more than that. But if you settle for what is due to you, you had paid him 470. He'll pay you back 470 maybe, along with something more because you had to take some expenses in fighting out the case. Make it 5 at best. If you go to 8 lakhs,
In trial court, 3 years.
I will send him to behind the bars because he cannot pay. Then you will go to have it executed. You will find a test house. You will find a test house on somebody else's land, which may also be government land.
Date may be fixed in 2 weeks.
Then all the Kadhai's buttons is not going to get you 8 lakhs, is it?
I will also take instruction on that.
List again on 18th of September 2026, allowing the parties to have talks of compromise. list of the learned counsel for the petitioner has submitted that the petitioner would make utmost efforts to have the matter settled by having discussions with the respondent. Also suggest your client.
What's up?
Otherwise, he has got no case with two courts coming to a concurrent finding.
yes, well,
Yes.
There is no scope for him.
But only buying time,
Yes.
and his time is also not very good now.
Yes.
Sir, his time not being very good.
Yes. Therefore, on the last occasion, I made clear.
Offer him that 1 lakh first. The one that you admit taking.
They have to.
Offer that first, that okay, this is the 1 lakh.
Yes,
Now I
something
can pay
like
370. Huh?
2024, they obtain stay order.
On this,
My lord,
without a deposit.
without deposit, my lord. Thereafter, case was not listed. I am pursuing to list the matter then, my lord.
Now, 18th of September, if it comes before this court,
Yes.
either you pay on a compromise or you pay by coercion.